Chairman Script here. As Chair of the House Fish and Game and Marine Resources Committee, I find that due to the state of emergency declared by the governor as a result of COVID-19 pandemic and in accordance with House Rule 67 and the Governor's Emergency Order 12 pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing of bills referred to the Fish and Game and Marine Resources Committee. Executive session on pending legislation may be held at any time. Please note there is no physical location for members of the public to observe or listen contemporaneous to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during the meeting through Zoom electronic meeting platform, and that the public has access to contemporaneous listen and, if necessary, participate in the meeting by the Zoom platform or by telephone. All necessary access information has been made available in the House calendar or through the electronic calendar on the General Court website. The notice of this meeting complies with House rules and RSA 91-A. Anyone who has a problem accessing the meeting should call 271-3600 or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. I want to introduce the staff that are on the meeting assisting us. Jennifer Floor, our committee researcher. Please note that all votes taken during this meeting shall be done by roll call. Let's start this meeting by taking a roll call attendance. When each member states their presence, please also state whether anyone is in the room with you during the meeting and where you're at, which is required by the right to know law. Ms. Clerk, if you could call the roll.
Representative Khan.
Present.
The clerk is present. Representative Close.
Present.
Representative Spillane.
Present.
Representative Howard. Representative Craig.
Present.
Representative Love.
Here.
Representative McConkey substituting for Representative Wolf.
Present in my office, an employee may walk through from time to time.
Representative Kittredge.
Here.
Representative Dostie.
Present.
Representative Representative Smith.
Can't hear you.
Representative Smith.
I'm not seeing him online.
Representative Harvey. Here. Representative Laflamme.
Present.
Representative Dontonville.
Here, alone in my kitchen.
Today. Representative King.
Present.
Representative
You
Egan.
can't hear.
Representative Egan. Representative Ruprecht.
Present.
Thank you.
Representative Egan is present and at home in my home in Sugar Hill by myself.
Representative Egan. Representative Ruprecht. Representative Shurtleff.
I am at my residence in Ward 1 of Concord, the village of Pennacook, and I'm alone.
Thank you. Representative Ellis
I'm here in Rochester. I'm alone.
and Representative Oxal. Oh, and Mr. Clerk.
Representative Lang, I'm here at the office.
I'm sorry, Mr. Chair. I didn't get a lot of.
Thank you. We have a roll call of the committee as being present. We'll move on and open up our first public hearing, which is on Senate Bill 129, relative to minimizing environmental impacts of habitats of endangered or threatened species. And to introduce the bill, I recognize Senator Jeb Bradley.
Good morning, Mr. Chairman. Good morning, Mr. Chairman.
Good morning, Senator. Thank you for being here today, and the floor is yours, sir.
Thank you very much. Pleasure to be with you and all your committee members. For the record, Jeb Bradley from Wolfboro. Pleased to be the sponsor of Senate Bill 129. It passed the Senate on a bipartisan vote of 21-3. The background of the bill is as follows. There was a court case in New Hampshire that changed the way that alteration of terrain permits were judged by both the Department of Environmental Services and Fish and Game, and a very rigid reading of the statute ensued that basically has created a logjam, a backlog, whatever you want to call it, of alteration of terrain permits. And alteration of terrain permits are for 100,000 square feet and larger projects. This backlog of permitting has really had a negative impact on contractors, on home builders, on projects throughout New Hampshire, as the very rigid interpretation of wildlife issues was different from the way these permits have been adjudicated in the past. And so I was approached by the contractors and the home builders. I worked with DES and Fish and Game to come up with the language that is in the Senate passed version of Senate Bill 129. And as I said, it had an overwhelming bipartisan vote in the Senate. So, Mr. Chairman, if I can just briefly walk through what the bill does, I would appreciate that. And I think the word appreciate is perhaps the most important word in Senate Bill 129. And you see it first on line 7. The way the current statute reads with regard to the way these permits for conservation of endangered or threatened species reads right now, and was subsequently interpreted by the court, they do not jeopardize. And so by adding the word appreciably, it mirrors the way that, first of all, the Endangered Species Act has been written, appreciably jeopardized, and it returns, if you will, to the way that these permits have been judged in the past before this court case. And then it goes on lines 9 through 11, requiring such action designed to avoid and minimize harm, and again, appreciably jeopardize the continued existence of such species. And it calls for rules being adopted by the executive director of Fish and Game to implement this new statute. And through that rulemaking process, then all entities will be able to participate. I think this is a balanced approach to the need. And quite frankly, the contractors and the home builders and all of the jobs related to those industries have signed off on this legislation. In conversations and, if you will, negotiations with environmental groups led by the Nature Conservancy, sections 2 and 3 in the bill were added so that in the event that there was a need for mitigation of wildlife impacts, similar in the way that road projects and wetlands can be done, a mitigation fund would be set up for unavoidable impacts to wildlife or wildlife habitat. And so that's broken down into species that are threatened and endangered versus those that are not threatened and endangered, and funding, if there are unavoidable impacts, to go into, both of those funds in sections 2 and 3. Again, signed off on by the entities that would, like contractors, et cetera, have to, potentially pay funds into this fund in order for a project to go forward. If you look on page 2, there is legislative oversight with a report by October 1 of 2022, and every year after that. So the legislature will have a role to play in looking at how these funds are utilized. So in a nutshell, I think that this is a approach that has gotten broad support. It's absolutely essential if we are going to protect the jobs of hardworking men and women in the construction industry of New Hampshire, that this bill go forward as expeditiously as possible, as those permits are backed up in this logjam created by the court case. So with that, Mr. Chairman, I thank you and would be happy to answer any questions.
Thank you, Senator. Appreciate that great introduction. And I'll recognize Representative Shirtliff, who seems to have his hands up for a question.
Thank you, Mr. Chairman. And Senator Bradley, it's always nice seeing you, if only remotely. I have, the first question I have is, you mentioned, Senator, that word appreciably came out of the Endangered Species Act of 1973. Was that word in the original act, or was that part of the U.S. Congress's amendment of the Endangered Species Act in the last Congress?
I don't know the answer to that question, Representative Shirtliff. I was told as we worked through the bill by all sides that appreciably is the word that's used in the Endangered Species Act. So when and how it might have been placed there, I can't answer for you.
Thank you. Follow up, Mr. Chairman?
Absolutely good, Representative.
Thank you, Mr. Chairman, and thank you, Senator. This bill will give sole authority to the executive director of the Fish and Game to determine what projects may cause an unavoidable impact on wildlife and habitat.
So under the legislation, the executive director would have to adopt rules. And then as these permits are adjudicated, obviously wildlife interests are something that the Fish and Game Department looks at, but this is a DES related permit. So there's participation by both agencies.
And one last follow-up, Mr. Chairman.
Absolutely, sir.
Thank you, Mr. Chairman. Not having a life, I actually read the Supreme Court's decision in remanding Weyerhaeuser v. U.S. Fish and Wildlife back to the Fifth Circuit. And their concern was on the definition of habitat and critical habitat, and that the Fifth Circuit failed to distinguish between the two. Do you know if in New Hampshire we do have a definite definition in law between what is a habitat and what is a critical habitat?
That would be a question I think best reserved for the Fish and Game folks that I'm assuming are going to testify on this bill, or DES. Again, I would just stress how important it is for all of the contractors and the jobs that they represent, and they will be testifying, I'm sure, today also, that we have this balanced approach to these wildlife issues as part of alteration of terrain permits. A approach that is what's happening right now is going to upend the ability of hardworking men and women and their employers to be able to do this kind of work as the logjam just gets worse and worse and worse.
Thank you, Senator. Thank you, Mr. Chairman.
Thank you. Mr. Sorensen from Fish and Game will be up next to talk, so we'll for future questions. Representative Donville, you have a question? You had to unmute yourself. Go ahead.
Thank you, Mr. Chairman. This isn't a question for Senator Bradley. Senator Bradley, thank you for showing up today. I can hear everyone who's remote much clearer than I can hear people who are in the Fish and Game Committee. Is it possible for them to raise the volume for the people, for the microphones in the Fish and Game Committee room?
So thank you for that. Jennifer, can we see if we get IT to come down and maybe raise the gain on the outbound speaker for the room?
Sure, I can contact them right now.
Mr. Chair,
who is that?
that it's Representative Egan. My video has fallen out, so I've rejoined on just through the telephone. So I just wanted to make sure that the record was aware that I am attending and only by phone. So my apologies.
So Representative Egan, that's fine. If you decide to exec anything, though, you'll need to have video for the exec.
I will make an effort to get it back.
Great, thank you. Representative Harvey.
Thank you, Mr. Chairman, and thank you, Senator Bradley. So I understand that some of these definitions would be handled through rules and rulemaking, New Hampshire Fish and Game. But is there anything in this bill that mandates that that actually take place?
If you look, Representative, on line 10, 11, and 12, shall be defined in rules adopted by the executive director. That obviously means that the Fish and Game director will have to bring rules to Jelcar.
So that word shall is what you're pointing to.
The word shall, I think, is pretty strong in its intent.
Follow-up.
So does that also apply to a definition for the word appreciable?
Well, if you look again on lines 9 through 12, it says, for the purpose of this statute, then in quotes, appreciably jeopardize the continued existence of such species, end quote, shall be defined in rules adopted. So that's exactly what the intent of Senate Bill 129 is to ensure that, the executive director pursue rules, take them to Jelcar through the normal rule approval process.
Thank you.
Mm-hmm.
Representative McConkey. Your hand is raised.
Thank you, Mr. Chairman. Senator Bradley, nice to see you. And thank you for bringing this forward, because the word logjam is a kind word that's happening to contractors up here and to the people that are issuing those permits or trying to. I'm always, so I applaud what you're doing here. My concern is rulemaking, and I'm hoping we'll hear from Fish and Game later that they're ready to roll this out quick, because I would use the word crippling at this point to what's happening out there. And I'm hoping we'll be able to hear that if we can get this passed, that this will be something that can happen sooner than later. And thank you for your efforts.
Is there a question? Is there a question? Was there a question?
Well, I would just chime in. Obviously,
There is a
Representative
question.
McConkey is very familiar with the alteration of terrain permitting process. He's exactly right. I was probably being kind when I said it was logjam as opposed to crippling. And it would be my hope that this would be a top priority to get in front of Jelcar.
Thank you, sir.
Any questions from the room? Okay.
Thank you, Mr. Chairman. Good morning, Senator Bradley. I understand by reading the bill that it would be up to the executive director of Fish and Game to decide what habitat would be critical. I'm questioning DES's role. Would DES be responsible for deciding what was appreciable, because they are the ones who ultimately do the permit, or am I confused there?
So my understanding of the way that the permitting process works, alteration of terrain is a DES permitting process. But as part of that process, they consult with the Fish and Game Department about critical wildlife and wildlife habitat. So there is a dual role, if you will, but the way the statute is constructed, it's the executive director of Fish and Game that has to promulgate and bring the rules before Jelcar on the habitat issue.
Thanks, Senator. I'm just gonna make a statement for everybody, because I did speak with the executive director of Fish and Game regarding the number of permits that were pending. As of middle of March, there were a little over 85 permits, I believe, that were pending. Fish and Game taking action. They've since taken action on over half of those and dealt with them. And they're moved, the rest they're supposed to have done within the next month or so and move those permits ahead. So just so, and I'm sure we can ask Mr. Saunderson about this from Fish and Game, but just so you understand what all that logjam looked like, what they were talking about was 90 building permits throughout the state that were held up that required an AOT. And as part of that AOT, they needed Fish and Game involvement. And Fish and Game, because of that law, was waiting to, wasn't quite sure what to do. So I do have a question for the senator. So my question to the senator is, Senator, if I understand this bill right, and what this bill is doing is taking a process that we've had in the past that didn't have good sides and good boundaries around it. And that's exactly what we're doing. We're putting some rules, some sides and boundaries. In this case, of when we're dealing with the money aspect of it, we're actually creating a fund now that will allow for this money to go into the fund to be able to offset and use for rehabilitation of habitat. Is that my understanding of the bill? Is that correct?
Yeah, I mean, that is correct. And unfortunately, due to the court case, the process for adjudicating these permits is, I think, Representative McConkey said it best. It's crippling. It's off the rails, and a lot of jobs are at stake. So by the process that's outlined in Senate Bill 129 with, the balance of protecting habitat, mitigation efforts, but also a much more prompt adjudication of AOT permits will allow, this logjam, backlog, whatever you want to call it, to, get worked through the system and not have this problem, hopefully, in the future. These permits were adjudicated in a much more timely fashion before the court case. Now, these big projects, I mean, when they're being financed, jobs are at stake, timing is everything. And to have this kind of delay with this many jobs at stake, and, the economy of our state is so dependent on construction, to me is unacceptable. And I think Senate Bill 129 strikes the appropriate balance.
Thank you, Senator. Representative Howard has a question.
Thank you, Mr. Chairman. Thank you, Senator Bradley, for taking my question. Do you know by any chance what year that this permitting process went into effect originally?
I think the court case was in 2019, but it's fairly recent. I believe it was 2019, but others can probably better answer that.
Okay, because I remember this permitting process from 20 years ago, and it seemed like it was a lot longer before that. Follow up for the second question?
Absolutely. Follow up.
All right, thank you, Mr. Chairman. Now, this bill will actually increase fees for applicants.
If there are, if there are unavoidable impacts, there could be funds paid for mitigation. But remember, what I have indicated all along, and you'll hear this testimony from the home builders and contractors, that this is a cost for them of doing business. And the time that permits sit on people's desk because they take so much longer now to review is so much more costly and has so much more of an impact on jobs than the mitigation funds or the fee costs. This is a acceptable cost of doing business. So don't take it from me that's the case. Ask them that question, because that's the answer that they overwhelmingly gave the Senate.
Could I have one follow up to that?
One thought. Still, we have 8 speakers. We have 8 speakers that are still pending, including there is somebody from the Hampshire Home Builders.
My question is on, will it be a sliding scale for that fee? Or is a violation a set fee no matter how severe?
That would be a question better asked of the departments.
Okay, thank you.
Any further questions for Senator Bradley? Representative Love, go ahead.
Thank you, Mr. Chair. Thank you, Senator. I'm just a little concerned about the cost of fish and game. Having somebody go out and inspect and do all the paperwork and stuff. I don't see anything here where they can attach any of these funds for that purpose.
Senator.
I apologize. I only heard a little bit of that question.
So I'll rephrase. So the question is that, from Representative Love, is that there's going to be a cost of Fish and Game to go out and do inspections and stuff, and there's doesn't seem there's any way in this bill for the Fish and Game to recoup that labor cost that'll be added to them. Is there supposed to be a way of doing that?
Again, that would be a question best asked of Director Mason.
Thank you. Any further questions? Great. Thank you, Senator, very much.
Thank you very much, Mr. Chairman, members of the committee. Thank you.
So next up will be Mr. Paul Saunderson from Fish and Game, the legislative liaison.
You're on mute already.
Thank you, Mr. Chairman. I believe that I am unmuted. This is Paul Sanderson, the legal coordinator of the Fish and Game Department. I want to thank Senator Bradley for his introduction of this bill and his attempt to answer the vast majority of questions that have been posed. I really don't have very much to add other than my ability to answer some of the questions that have been asked by members of the committee to this point. And with the permission of the chair, I would attempt to do those right now.
Absolutely. Go ahead, Paul.
Thank you. Moving to Representative Shurtleff's questions. One of the things I want to point out to folks is that the Federal Endangered Species Act is the Federal Endangered Species Act, and that's administered by the U.S. Fish and Wildlife Service. We're talking here RSA 212A, which is the state equivalent, where the Department of Fish and Game is administering a state list of threatened and endangered species. It is somewhat different. So what we're trying to do here is to move the standards under the state act to become much closer to those contained in the federal act. They don't have to be absolutely identical, but what we're trying to do is move it closer so that when these matters are adjudicated in our state courts, there is an entire body of federal law around the Endangered Species Act that our courts can use for guidance as to the meanings of these critical terms, including appreciably, the meaning of habitat, the meaning of critical habitat, which have been extensively litigated at the federal level and in fact are the subject of federal regulations, which I cited to you in my testimony. So that is the reason why these words have been proposed and why these words are important. As to Representative Harvey's question regarding rules, I must tell you that these particular rules are in fact of the very highest priority. There is a working group between Fish and Game Department and the Department of Environmental Services that meets on a weekly basis to propose changes to rules to try to implement these new standards. In fact, we have already drafted some proposed changes which went to an unusual joint pre-rulemaking hearing process where we've already sought comment, not only from the regulated community, but also from the environmental community. That was conducted and we've received that, and we're moving on towards our next draft so that we can in fact propose rules in the very near future. With respect to questions that really had been asked by Representative McConkey and Howard and Love regarding resources at the Department of Fish and Game. Understand that there are no fees that come to the Department of Fish and Game for the conduct of wildlife assessments and reviews. And so therefore, we have been performing these tasks with existing staff using resources from our non-game program and also from federal grants. We do not receive any portion of any application fee that has been filed by an applicant with any other state permitting agency. And so are resources an issue? Yes. However, this is not a secret, and this is something that has been extensively discussed, not only with the governor's office, but also with House and Senate budget writers, and that process continues. With respect to Representative LaFamme's question as to whether DES would be the agency that would decide what is the meaning of appreciably jeopardized, the answer to that is no, that would not be conducted in their rules. It would be conducted in the rules of the Fish and Game Department, because these rules that we would be proposing affect not only Department of Environmental Services, but all other state agencies that may come before us with regard to requests for permits or requests for changes in land use on land that they own. That could include Department of Transportation, the Department of Natural and Cultural Resources, and others. I think that answers all of the questions which representatives have posed to this point, and I'd be happy to answer any other questions that any other representative would like to pose.
Vice Chairman Abul has a question for you. Go ahead, Vice Chairman.
Thank you, Mr. Chairman. Thank you, Mr. Senator Simpson, for taking my question. Is there a big difference when it comes to the list of federal endangered species and the state? Is there a very big difference between those two lists?
Thank you, Representative. The lists of federal endangered species and state endangered species, they are different. They are already contained in rules that have been promulgated by this department. They are different species. They're not the same. And the two programs are not administered in lockstep. We certainly cooperate with the U.S. Fish and Wildlife Service with regard to anything that is on the federal threatened and endangered species list. And we are working in concert with them often on state endangered species, but the two sets of species are different.
Representative Sherman.
Mr. Chair, this is Representative Egan with a question when I'm allowed.
Sure, give you right after Representative Sherman.
Thank you, Mr. Chairman. Thank you, Counselor. I didn't quite get an answer to my one question to Senator Bradley, and that was regarding the word applicability. Was that added? Was that part of the original Endangered Species Act of 1973? Or was that part of the revisions implemented last year in the combined federal regulations?
Thank you for your question, Representative. It was not in the original. It was part of the changes last year.
Thank you, Counselor.
Representative Egan.
Thank you, Mr. Chair. Thank you, Mr. Sanderson, for taking my question. Absent the word appreciably on page 1, line 9, would you see the agency supporting this legislation?
In other words, your question is if that word were not part of the bill as it reported out and ultimately passed? The answer to that is the language that is ultimately chosen by the legislature is the language that we will implement, and we will go through the rulemaking process with the that word in place or that word not in place. And we're going to be accepting comment from not only legislators, but also the public as we adopt our rules in an effort to try to improve the situation.
Thank you. Follow up, Mr. Chair?
Absolutely, go ahead.
Does that word make the rulemaking process for Fish and Game more difficult to make decisions clearly?
Thank you, Representative. In that regard, the word is important because if you are in fact a proponent of change on a particular piece of landscape, the word appreciably helps to modify and understand the efforts that you're trying to make as you alter that landscape. In the absence of the word appreciably, other people may argue that any changes to the landscape, in fact, are harmful to threatened and endangered species who may be present on that landscape. What it does, there is no ultimate resolution here. On each particular parcel, there is a balance between the impact to threatened and endangered species and the impact to private property rights. That is the very difficult job that staff of our department, as well as staff of other state have in reviewing every particular individual project.
Follow-up, Representative?
So thank you, Mr. Sanderson. As always, you are well educating us on the Fish and Game Committee. Thank you, sir.
Thank you.
Representative Harvey?
Thank you, Mr. Chairman. Mr. Sanderson, so the chair just told us that the number of cases that had been backlogged, and let's see, I wrote it down, 85, there were 85 permits that had been backlogged, that action has been taken on over half of them, and the rest will be taken up shortly. So what caused that backlog? I understand the court case is an issue, but if since there was a court case, would hiring more personnel to take care of these permits, would that have helped with that backlog in lieu of SB 129, I guess?
Thank you, Representative. As a result of the court case that has been referred to, which came down from the New Hampshire Supreme Court in November of 2019, the Department of Environmental Services enacted a rule in the spring of 2020, which made a fundamental change. And that fundamental change was that instead of past practice, which had been sending only those particular projects that had a demonstrated impact through the Natural Heritage Database over to this department for review, all applications to the AOT program came over to us for review. So that number, an increase in workload, is what has caused timing, because no new resources were available to be set to the problem. So changes that have occurred recently have been a return to past practice, saying that we will review projects that have a demonstrated contact through the Natural Heritage Database and not review every single project that comes through the AOT program. That has materially assisted in reducing the amount of time that it takes to handle the number of applications that we have received.
Follow-up?
So with those changes in mind, then, and it seems like you're moving forward through these backlogged permits, with those changes in mind, why do you foresee another backlog in the future?
Thank you, Representative. We foresee another issue going forward because there is simply more development that is occurring throughout our state. I would like to refer you back to Senator Bradley's comments, okay? That there are in fact many more opportunities that the private sector is using to attempt to develop property. They're doing so because there is a housing shortage in our state. They're doing so because there are tremendous needs throughout communities for development of other types of space. And so as development increases, more and more parcels are impacted, more and more will need review through the AOT and other programs. And so we do expect that the overall request for reviews and input will increase because of the general economic environment.
Thank you.
Any further questions for Mr. Saunderson? Seeing none, we'll move on to the next speaker, which will, I'm going to move now to our public members, members of the public. So first up is Joan O'Brien. Joan, if you could raise your hand so we can find you easier, that would be great.
I'm thinking it might be. I have allowed Jim O'Brien, but that's
So, the O'Briens, are you there?
Hi, Mr. Chairman. This is Jim O'Brien, not Joan O'Brien. Jim O'Brien, I'm the Director of External Affairs for the Nature Conservancy in New Hampshire. And I'm here today going to speak on behalf of the Nature Conservancy, but also 5 other conservation organizations in the state. And so I'll name them. So the New Hampshire Association of Conservation Commissions, New Hampshire Audubon, Society for Protection in New Hampshire Forest, New Hampshire Rivers Council, and the Appalachian Mountain Club. So thank you very much for the opportunity to speak. And I've sent in a letter of support for the bill that I hope you have received. And if not, I'll speak very briefly to some of the points in the letter. So first, I want to thank DES Fish and Game. We've been working with them over the course of the past year or so on a lot of what you just heard about the rulemaking that's been ongoing on this issue. And also thank Senator Bradley. We worked with him and his colleagues in the Senate on some of the language in the bill that you have in front of you. We are here to provide some testimony in support of Senate Bill 129. We support the concept of the bill, and I think as Senator Bradley spoke, we very supportive of the mitigation fund and how it's established in the bill in Section 2. I do want to note, I know you've talked and heard testimony on the term appreciatively. We do, I think as a conservation community, we oppose, I guess is the right way to say it, the inclusion of that word on page 1, line 9 of the legislation. We think that including the term in the statute only confuses the issue and may lead to increased litigation over the course of time for department decisions. As Mr. Sanderson just said, the department is undergoing a rulemaking process. They had a hearing last month where these terms like jeopardizing the continued existence of species are being defined. We feel that that's a better place with the wildlife biologists and the experts with the Department of Fish and Game to be making qualifiers around the Endangered Species Act and not leaving it up to the legislature to do that. We think the rulemaking process is the proper place for those terms to be defined and to be executed. And I'll just say on the rulemaking side, we are very supportive and very pleased that Fish and Game is moving forward with rules on enforcement and decision-making around the Endangered Species Act. Currently there are no rules. And so while I know there's been a court case, Fish and Game doesn't have any rules for defining terms like critical habitat, jeopardizing continued existence of species, or even how they go about making decisions on which impacts are so great that avoidance or minimization or payment into a mitigation fund would be appropriate. So we just feel that the rulemaking charges, both in Section 1 and Section 2 of this bill, are really important. We understand that there is movement on rulemaking, but I think the legislature putting in the statute that the expectation is that within a year, these rules will be executed and moving forward, we feel is the push that the department needs because we have been working, and not saying there's been anything wrong, but this permitting process has been in place now for years, and the department still doesn't have any rules that show us or the public what's guiding their decisions on what's appropriate and what's not. With that, as I mentioned, I did send our testimony, so if for more information, you could read that. I'm happy to answer any questions from the committee. Thank you so much.
Okay. Any questions for Mr. O'Brien? Representative Shertliff, go ahead.
Thank you, Mr. Chairman, and thank you, Mr. O'Brien. Mr. O'Brien, I got your letter and I appreciate you and the other groups sending that to us. On the word appreciable, if the bill were amended to remove that word, would you and your colleagues find the bill far more amenable? And I feel the word appreciable is like beauty. It's really the definitions in the eyes of the beholder. So would you think removing that word would improve the bill?
Thank you, Representative, for the question. I think the short answer is yes. When I think about the term that appreciably is qualifying, I mean, it's jeopardizing the continued existence of a species. And so it's hard to think of putting a qualifier in front of jeopardizing the continued existence. You either are doing it or you're not. And so to us, anyway, defining the term jeopardizing the continued existence of a species makes more sense than trying to qualify it before you even get to a definition. And the definition in federal statute for jeopardizing the continued existence of a species, as well as the draft rules that Fish and Game put out for comment a month ago, includes the words appreciably, but it isn't qualifying jeopardizing the continued existence of a species. And I could read the paragraph, I hope that it clarifies a little bit. So this is the federal definition. The federal definition is jeopardizing the continued existence of means to engage in an action that reasonably would be expected, directly or indirectly, to reduce appreciatively, so there's a term, to reduce appreciatively, the likelihood of both the survival and recovery of a listed species. And so anyway, that was a very long rambling answer to your good question, Representative, but I do think we would, I think removing that term, we would support that. And our hope is that through the rulemaking process, the Fish and Game has already said they're undertaking, the concerns around that would have a public process that could then be defined in a more clear way.
Thank you. Thank you, Mr. Chairman.
Further questions for Mr. O'Brien? There being none, thank you. We'll move on to our next speaker, which will be Ms. Ralph Valentine, member of the public.
Good morning, Mr. Chairman. Can you hear me?
I can, sir. Go ahead, sir.
Thank you very much. Thank you, Chairman Lang and members of the committee, and thank you, Senator Bradley, for the bill. My name is Ralph Valentine. I am the chair of the Public Policy Committee of the New Hampshire Commercial Investment Board of Realtors. I am here today testifying on behalf of 7,000 plus realtor members in the state in support of Senate Bill 129. The bill ultimately surrounds the state application, the AOT application, and each time a business owner, homeowner, or developer disturbs about 2 acres, the permit's required. As we know, the current permit requires the applicant to report on any impact on endangered species. The legislation comes in wake of the Supreme Court case, placing additional burdens on the applicant to have Fish and Game validate what is already reported by the applicant. Prior to that case, the process was about 6 to 10 weeks. And according to conversations, that time is almost doubled. The legislation and the rulemaking should provide the balance that we wish to weigh between private property rights and environmental protection. Without the bill, new job creation will be delayed, whether they are temporary construction jobs or permanent jobs, which are the result of business expansion. And more important, without this bill, there's a delay and a cost of delay of the entitlement process will exacerbate the housing shortage. So we do support this bill in its current form. Thank you.
Thank you. Any questions for Mr. Valentine? Seeing none, thank you, Mr. Valentine. Appreciate it. Next up is Suzanne Fournier of Milford, New Hampshire. Suzanne, you.
Oh, she raised her hand. That's fine. She went to the top. I was looking at the bottom.
Thank you, Suzanne. You can unmute yourself.
Hello, good morning. Good morning.
We can hear you.
Hello, you can hear me now?
We can.
Very good. Yeah, it asked me to unmute a little box. So good morning. Yes, Suzanne Fournier. I'm coordinator of a grassroots group in Milford called Brock's Environmental Citizens. I'm here to ask you to oppose SB 129 because it would weaken protections afforded to wild species of animals who are already in jeopardy, the most jeopardy. The bill, if you look at it, begins with this powerful directive, and I quote, all other state departments and agencies, to the extent possible, consistent with their authorities and responsibilities, shall assist and cooperate with the executive director in the furtherance of the purposes of this chapter for the conservation of endangered or threatened species, unquote. And what is the statute's main purpose? It's found in section 3 of the law, and it reads, quote, species of wildlife normally occurring within this state, which may be found to be in jeopardy, should be accorded such protection as is necessary to maintain and enhance their numbers, unquote. But this bill allows harm to the species that are already in jeopardy. So how can anyone expect that the species will do okay being harmed? By the way, minimized harm is just another way of saying that the harm is controlled, regulated. The harm that would be authorized under this bill would be regulated and minimized, but it would not be harmless. So Fish and Game recently defined harm in a definition that is tailored to fit the types of harm that are experienced by the endangered species. It's harm that happens to them as a result of permitting decisions made by departments like the Department of Environmental Services. Fish and Game's definition of harm is this, and I quote, "Harm means any act which actually kills or injures individuals of a threatened or endangered species, or which acts to destroy, degrade, or adversely modify the habitat supporting the species by interfering with breeding, hibernation, reproduction, feeding, sheltering, migration, or overwintering behaviors that are a part of its normal or traditional life cycle and that are essential to its survival and perpetuation," unquote. That's from Fish and Game. That's the definition of harm. And that is exactly the kind of harm that this bill would allow to happen. It would be harm to the habitat, supporting the species by interfering with the animal's behaviors that are essential to their survival and, very important, perpetuation of their own species. Remember the purpose of the 212A? To maintain and enhance their populations. A last important point, although you didn't hear it mentioned by Attorney Sanderson for Fish and Game, the Fish and Game Department, the Fish and Game Commission of the department, they voted to support SB 129, but I want you to keep something in mind. That is the Fish and Game Commission. Fish and Game Commission. We're not talking about fish and game. That commission is not known as the Fish and Game and Non-Game and Endangered Wildlife Commission. Where is their expertise? It isn't there. You should have heard directly from the Non-Game and Endangered Wildlife Program on what they think this bill does to endangered wildlife. Instead, you heard from Attorney Sanderson, and he said an awful lot about development and balance. He did not say an awful lot about the purpose of 212A and protecting the species. So I hope you will continue to support the act as it is. It is a good act. It is strong. Okay, and I hope you will reject SB 129. I thank you for listening.
Thank you, Ms. Fournier. Are there any questions for Ms. Fournier? Seeing none in the room, seeing none in Zoom, I appreciate it. Thank you very much. Next up is Kurt Ehrenberg.
Hello, Chairman Lang, members of the committee. My name's Kurt Ehrenberg. I am the State Director, New Hampshire State Director for the Humane Society of the United States. You do have written testimony, I believe, from us, from our affiliate, the Humane Society Wildlife Land Trust, formed in 1993. The trust is an affiliate of the Humane Society of the United States and protects over 21,000 acres in 32 states, including over 1,000 acres in New Hampshire. I appreciate the time. I'll try to be brief. Just to sum up, while we support the concept of the bill, we believe vital changes are needed so that the original intent of the legislation is fulfilled. If passed, Senate Bill 129 would allow state agencies such as the Department of Environmental Services to authorize development projects that could cause harm to wildlife. This is a bill designed to speed up the authorization process of development permit applications that are backed up for review by the New Hampshire Fish and Game Department. But rather than choose to allow possible destruction of wildlife habitat, the department should be hiring more staff to carefully review permit applications. Ultimately, this bill would legalize harm to threatened and endangered wildlife species that is prohibited by existing law. As it stands, there are no administrative rules or other public documents that establish a clear process or criteria for the Director of Fish and Game to reach conclusions under RSA 212A. It also does not require the Fish and Game Department undertake a rulemaking process to define the terms. The Fish and Game Department must develop rules to clearly show how they define critical habitat, how they will decide if projects avoid impacts to wildlife habitats, and how they will determine the penalty when wildlife harm is done. That's our position on this bill. I'm happy to take any questions.
Thank you. Are there any questions, Mr. Ehrenberg? Seeing none in the room, seeing none online. Thank you, Mr. Ehrenberg. Appreciate it very much. Next up is Gary Abbott. Gary, if you're on the screen, can you raise your hand?
Thank you, Chairman Lang and committee members of the Fish and Game Committee. Thank you for this opportunity. My name is Gary Abbott. I'm the Executive Vice President of the Associated General Contractors of New Hampshire. I'm here today in full support of Senate Bill 129, and I would like to fill in some blanks. I know Senator Bradley did an excellent job answering questions, but I wanted to talk a little bit about the reason for this statute change. We had been, I'm talking from an applicant's perspective. I represent general contractors, I represent sand and gravel, and developers who do large projects. The prior in 2019, we had a process in which you would file for a alteration of terrain permit. You would go through the DES. If you would end up with a National Heritage Database hit, you would be referred to Fish and Game. Fish and Game would then do a review of that hit, which only meant a smaller percentage of those alteration of terrain permits went to Fish and Game. Now, that doesn't mean in 2019, I wasn't in Director Normando's office looking for rules and guidance, because some of those permits got held up. But it was a very small percentage. So you have to understand that process. In that process, we use pretty much the terminology that's in this proposed bill. The Fish and Game Department would ask developers to minimize or avoid impacts to these wildlife habitats. What is the language in this that avoid and minimize just wasn't in this statute. This statute was written more than 20 years ago. The court case highlighted that the statute needed to come up to what we were doing prior to 2019 and the court case. The other language that you've been talking about is this appreciably, and I want to talk about that. If you remove that word, there will be more court cases, in my opinion, because it will say, do not jeopardize. It will not give the Fish and Game the leniency that they currently have and that they had in the past regarding asking developers to minimize the impacts that are currently exist. So it would have a very bad impact. That is why this bill fits with the Fish and Game and DES updating their rules. The other thing that seems to be missing from the conversation from a developer's, we supported the temporary rules proposed by DES back in January of last year. We then even supported the rules in June that really caused the backlog of permits. Part of those rules in June asked the developer to hire a wildlife biologist to do the work, the investigation on projects. I never, when I agreed to supporting those rules, thought it would be every permit. I thought it would only be those that had some kind of impact or some kind of recognition of a threatened and endangered species on the project. But instead, it became all the projects. The developer assumed the financial responsibility to hire those wildlife biologists and still submitted, in which most permits by DES are a 90-day turnaround turned into months and months. So you can understand my position as the vice president of the Associated General Contractors. I started to receive not only from those that have applications in, those contractors who hope to start those projects this spring saying, what's going on? So from our perspective, We need this legislation passed to make it clearer to what we were doing in 2019, to make sure that there's not a new interpretation of much stricter. And part two is rules. And I really appreciate what DES and Fish and Game have done doing the pre-rulemaking hearing. I know there was a lot of comments. We wrote our comments at what those rules should look like and what changes in their draft proposal. We look forward to working with them. But I think what you have to recognize is this statute is really so Fish and Game, the director has the ability to do some judgment calls on those projects that have wild, endangered and threatened species. I think Representative Shurtleff asked a good question about habitat, because I think that's part of the new broad interpretation. If there is no endangered species, but the habitat could be good, there's some gray area. Hopefully through the rulemaking process, we can clarify that. I don't think it has to all be in the statute. So I asked that the Fish and Game Committee pass this bill as it was passed by the Senate. It has been worked on by a number of groups, as you already heard. It's been worked on with DES, Fish and Game, and even the Attorney General's office. So I wanted to put that in. We have been working on this bill for the last 6 months in the sense that something needs to be fixed. This seems to do it. I would not remove any of the language or change it. Trust me, appreciably did not start out as that word. We had many other words that were tried to be used, and that was the best word we could find. So with that, I would end my testimony and answer any questions. And thank you.
Thank you, Mr. Abbott. Are there any questions for Mr. Abbott? Representative Harvey.
Thank you, Mr. Chairman. So did I hear you correctly when you say not everything has to be in legislation, that some of it could be in rules? And if I heard you correctly, then why wouldn't this bill and its definitions be in rules and not in legislation?
I actually answered the same question before the Senate. The Fish and Game and DES have to comply with whatever the legislation says. So this being in the statute clearly gives the directive of what the legislative intent. I don't think 20 years ago we were talking about avoid and minimize. Those have things that have progressed over time. So we really do need it in statute, but there's a lot of clarification, appeals process, a lot of things that have to be done in rules that don't end up in statute. But I think this is the guideline, and it's clear to me. If you just have do not jeopardize, there'll be a lot more court cases saying any little thing can't be, you can't minimize it or avoid it. So that's really the issue that we have. But don't get confused. I think the statute does guide the agencies in their rulemaking. So this is very important.
Any other questions for Mr. Abbott? Seeing none online, seeing none in the room. Thank you, Mr. Abbott, for your testimony. I appreciate it very much.
Thank you.
Next up is Ari Pollock. Ari, if you're there, if you can raise your hand. There we go. Ari, you should be able to unmute yourself and go ahead.
Good morning, Mr. Chairman, members of the committee. Are you able to hear me?
I can, sir. Go ahead.
Super. My name's Ari Pollock. I'm an attorney practicing with the law firm of Gallagher, Callahan, and Gartrell, and I'm appearing before you this morning as a registered lobbyist for the New Hampshire Home Builders Association. The Home Builders Association includes residential builders and remodelers across the state of New Hampshire, and we support Senate Bill 129 as was amended and passed by the Senate. The bill addresses a critical permitting backlog that is threatening land development and economic growth across the state. As a 20-plus year New Hampshire land use attorney and a longtime lobbyist for the New Hampshire home builders, I understand and appreciate the need for balance in environmental and development policy. And when matters swing too far towards protection, projects that are critical to housing, jobs, and the economy suffer. And vice versa, when matters swing too far away from protection, our natural environment suffers. And as I'm sure all of you on this committee are aware, neither extreme is desirable. And this bill addresses a real and urgent situation where the pendulum has swung too far to one extreme. Prior speakers have covered a lot of the material I had intended to address, and so I'd like to move quickly to some of the discussion points that were raised this morning. The question about whether or not it would be prudent to remove the word appreciably before or within do not jeopardize, I think that would be a tremendous mistake. Do not jeopardize led to litigation, which led to an interim rule, which led to a critical backlog. We know how that language was interpreted. We know what that interpretation caused. What this bill does is provide a very important legislative reset, a rebalancing, if you will, of how that pendulum swings over time and puts it back in a place where environmental concerns and economic concerns can again move forward together. It restates the policy and hopefully leads the next time the court reinterprets legislative intent to an intent to a more modified, more balanced, more results-oriented landscape. As Mr. Abbott was just talking about, the reliance on the Natural Heritage Bureau database used to perform this function for us. It used to either generate a quote unquote hit for sensitive species, listed, threatened, endangered species, or not a hit. And that was something of a triage system for whether or not you needed to have a discussion with the professionals at Fish and Game. If you had a hit, you had something to discuss. If you didn't have a hit, you didn't have anything to discuss, and you proceeded with your engineering discussion with the professionals at the Department of Environmental Services on your alteration of terrain engineering. The word appreciably installs that triage into the statute. It's a legislative statement of policy as to whether or not there is something to discuss, whereas the fallout from the litigation said everything has to be discussed. Let's do a wildlife study on every case, or every permit application rather, and let's send every permit application to Fish and Game with that study, and let's wait for everything to be reviewed and sent back. And of course, the result was a tremendous backlog, way too much work to process, and way too much delay for contractors who can't commit to projects, can't hire their workforce, and can't, of course, deliver the projects that our economy and our housing industry needs, and our workforce needs. So I think it would be a big mistake to remove the word appreciably. It modifies do not jeopardize in a way that is responsible, but also returns us to some balance. And the notion that policy can be set in rulemaking, policy is set at the State House. And all of you were elected to make those determinations for your constituency and for the state. Rules must fit within statutes, and I know you all appreciate that difference and distinction. It would be unfortunate if that word were removed. There's already been one case, and I think it's quite likely there'll be more, and that word will be important if the court is again asked to interpret the language in this law. With that, I'll end my testimony and simply ask for your support on this bill, which comes with a sense of urgency. As you know, well, notwithstanding last week's snowstorm, the weather is improving and we are in the midst of the construction season, and jobs are at stake and on the line. So there is really a sense of urgency to get this bill through the State House and to the governor's desk, and the Home Builders Association certainly requests your support. Thank you very much, and happy to take questions.
Thank you, Ari. Are there any questions for Mr. Pollock? Seeing none in the room, seeing none online. Thank you, Mr. Pollock, for your testimony.
Thank you.
Is there anybody else in attendance of the meeting that wishes to speak? I see Amy Charbonneau, I think your name is. If you could unmute her, please. Amy, go ahead.
Hi, thank you, Mr. Chair and members of the committee. I just wanted to speak. I'm from Continental Paving. My name's Amy Charbonneau. Everybody keeps talking about backlog, and I just want to give you the real version of what backlog means to us contractors. In a COVID world, everything's backlog, but to us, this backlog is real. So obviously, we're paving, we do large, heavy highway site work, but when fall comes or closer to Christmas, we lay off probably say 25% of our people just due to paving, the winter. what we try and do is keep as many people as possible, shuffle them to these type projects that we're talking about, large sites. Well, what happened this year is we didn't know when these approvals were going to come. So the ability to shuffle people, keep them working was near impossible. So we had 3 to 4 what we would call shovel-ready projects that we knew within 30 to 60 days, normally we'd be getting a permit for, and everything would be done. You know, that's 20 to 80 guys that now we can employ on large jobs. Well, now I can't shuffle those good employees that I have to those locations. It could be 6 to 9 months till I get that permit. So we ended up having to lay off more people than normal in the winter because of this backlog. So I want to really put an exclamation point on what that backlog truly means. It's not just papers on a desk, it's employees working, it's unemployment, it's all those things that New Hampshire contractors are really feeling because of this backlog.
Thank you, Amy. Any questions for Ms. Charbonneau? Seeing none, thank you again, ma'am.
Thank you.
Anybody else who wishes to speak, go ahead and raise your hand. Give that a minute. Linda Dion. Ms. Dion, if you can just restate your name and where you're from.
Hello, can you hear me?
I can, ma'am. Go ahead.
Okay, my name is Linda Dion. I'm the president of the Voices of Wildlife in New Hampshire. This bill, I'm asking you to oppose it. And it seems like this bill has come about because of a backlog. And part of the backlog problem is because of COVID. Everybody's working from home and everything was slowed down because of COVID. So that's part of the problem. Anyway, this bill will weaken the New Hampshire Endangered Species Act. This is no time to weaken our Endangered Species Act. We need nature. I'm sorry, I didn't prepare to talk. Because of pandemics and COVID, we're seeing the importance of nature, and we should not weaken our Endangered Species Act at this time because of everything that's going on with our environment. I would also like to say that developers, maybe they could donate to the non-game fund so that Fish and Game could hire more people to take care of this backlog. There is that solution, to hire more people rather than weaken our Endangered Species Act. And that's all I have. Sorry.
Any questions for Ms. Dion? Seeing none in the room, seeing none on Zoom. Thank you, Ms. Dion. I appreciate it. I'm going to ask Paul Saunderson to come back online. I have a follow-up question. Paul, are you available for a question?
Thank you, Mr. Chairman. I'm here.
Thank you. I just want to be clear as I'm reading the bill. The other thing is, Bill, that we've been talking a lot about the word appreciably, but other thing I see, I think if I understand the bill properly, I'm just trying to make sure I'm clear, is that this also establishes a new fund for Fish and Game, if I'm not mistaken, that any of these fees that may be assigned to contractors or developers, and that fund would then be a non-lapsing fund that would be for funding projects to facilitate net conservation benefit to threatened and endangered species. So not only do we have this language about appreciable, we also are by statute now creating a brand new fund that would give you resources to be able to mitigate any, for a net conservation benefit overall, endangered species. Is that correct?
Thank you, Mr. Chairman. Yes, that is correct. Those sections of the bill, they're really enabling legislation that enable the department to accept funds that are offered as part of permitting processes. Remember that here at Department of Fish and Game, we do not have permitting authority, nor do we have the authority to impose any sort of exaction upon anyone as part of a permit process. However, this would enable us to receive funds that have been offered voluntarily in other permitting processes and put them to these very targeted uses. And as was noted by Senator Bradley, with significant legislative oversight as to how those funds would be used for these particular purposes.
Thank you. One follow-up question. One follow-up question for you. I'm going to go back to the word appreciably because that's been the topic of conversation the entire day. So as I'm looking at this it seems to me what we're asking Fish and Game to do by this bill is to do similar things we do with when you're managing a herd, right? The deer herd. We don't tell you by statute how many permits they issue for hunting licenses or how many moose you can take or any of the other lottery type things, that you do that as part of your normal process to manage good herd management. And as I read this bill, at least the way I'm reading it, and then correct me if I'm wrong, is that we're asking you to do the same thing here, is to manage what's going on and to have you put into rules what you're going to use to manage that. Is that a fair reading of this bill?
It is, and understand too, that this is a bill that imposes a standard not only for the Department of Environmental Services, not only for the alteration of terrain program, but our relationships with all other state departments and all other types of programs. And so, yes, it is giving us a set of discretion to work with all of those other applicants, all of those other agencies in order to accomplish the statutory purpose.
Representative Parker.
I'm glad you brought Mr. Sanderson back. Thank you, because I had a couple of questions, questions pop up as we listen. So, Mr. Sanderson, so I did understand that there would be, in section 2 and 3, there would be ways for funds to be deposited with various places in New Hampshire Fish and Game. How those fees are determined, is that another thing that would be taking place in this very inclusive rulemaking process? I mean, like, will one person, how will you know that one person gets charged $10 and another person gets charged $10 million? I mean,
Yes, thank you for your question, Representative. The actual definitions and operation of a mitigation program would not be contained within Fish and Game rulemaking because we're not the permitting authority. We make recommendations based upon reviews to permitting authorities. And so whether or not mitigation payments are in fact required would be part and parcel of rules that would be adopted by other state agencies who are administering those permit programs. So the consistency between the rules in the various departments is something that is the task of GELCAR. So certainly as individual departments go forward with their permitting processes and as they develop a mitigation program that deals with these things, that's where GELCAR performs its function.
thank you. So I think I just heard you say that these funds would be voluntary. And so I'm just wondering, could that possibly lead to any expectation on the part of a developer that if I voluntarily pay more, I'll get my permit?
Thank you for your question, Representative. Again, as Fish and Game makes its recommendations based upon reviews of individual projects, it goes back to permitting agencies. Those permitting agencies have to be very careful as they develop and administer mitigation programs. And mitigation programs already exist. For example, the ARM fund, the Aquatic Resources Mitigation Fund already exists. So these questions have been asked and answered in other types of programs where mitigation is allowed. You raise a good question, but it is something that GELCAR is attuned to make sure that that sort of criteria is there and that it's not something where the wrong answers pertain.
Thank you.
Representative Abul. Thank you, Mr. Chairman, and thank you, Mr. Sanderson, for taking my one more question. Currently, many times the state agencies and the DES take recommendation or the advice from the Conservation Town and Cities Conservation Commission or regional planning commissions. Is it anything is going to change?
Thank you for your question, Representative. There's nothing in the bill that changes the local planning process or takes away any sort of local control over that particular planning process. They're contained in existing planning statutes. As you go through your local planning process, as you know, local conservation commissions, local planning boards, local zoning boards of adjustment all make their particular approvals contingent upon receipt of required state permits. So there is nothing here that changes that local process or changes the process of review in any particular municipality, nor does it impose additional costs upon any particular municipality.
Anything further from Mr. Saunderson? Seeing nothing in the room, seeing nothing online. Thank you, Mr. Saunderson. Is there anything else to come forward regarding Senate Bill 129? Seeing nothing, I will close the public hearing on Senate Bill 129. I will open the public hearing on Senate Bill 51 and welcome into the room Senator Bishardi, who was over doing other Senate business in the House. And Senator, if you want to go ahead and take it. So we're discussing Senate Bill 51.
Good morning, everyone. I'm Denise Rishardi. I represent District 9. I was asked to introduce this legislation by the New Hampshire Lodging and Restaurant Association. The genesis of this bill was a number of restaurants learning this past summer that they needed a license from the New Hampshire Fish and Game Department if they sell lobster that has been processed and packaged. Many of them had been buying frozen lobster meat from food distributors such as Sysco, U.S. Food Service, or Performance Food Group, and they never realized that they needed a license from New Hampshire Fish and Game. So I took part in a meeting with the New Hampshire Lodging and Restaurant Association and the Fish and Game Department to learn more about why are we requiring licenses for restaurants that purchase processed and packaged lobster meat. The explanation is that we need to license all those involved with the harvesting, processing, wholesale distributing, and eventual sale of lobster in order to protect the fishery of the Gulf of Maine. While I agree with this, I do not think it's necessary and effective or efficient use of the department's resources to license and to enforce the law on those restaurants that buy and sell processed and packaged lobster meat from food distributors. It's just overkill. We already licensed all of those involved well before the processed and packaged meat hits the restaurant. We license the harvester. We license the processor. We license the non-resident wholesaler, and we license the resident wholesaler. Under this legislation, if you buy processed and packaged lobster meat from a licensed wholesaler or processor, you will not have to obtain a license from the department. If you are a restaurant, however, that buys live lobsters, you will still have to get a license from the New Hampshire Fish and Game. This bill passed the Senate on the consent calendar. I'm asking you to recommend passage of this common sense piece of legislation, and I'm happy to answer any questions that you might have. But there are folks here from the department and the Restaurant Association that plan to speak that could possibly answer your questions a lot better. Thank you.
Any questions for Senator Rishardi? Seeing none in the room, none online. Thank you, Senator, for introduction of the bill.
Okay, thank you. I have to go back to my committee. Sorry.
Next up is Henry Belleville from the New Hampshire Lodging and Restaurant Association. Henry, you should be able to unmute yourself and go ahead.
Okay, thank you, Mr. Chairman. And members of the committee, for the record, my name is Henry Vayu, and I'm here on behalf of the New Hampshire Lodging and Restaurant Association. And fortunately for you, this bill is a lot simpler than the bill you just heard. I was on at 9:30 for the 9:30 hearing, and it was quite a complex bill. So this one is really simple. I affectionately refer to it as the lobster roll bill. And it basically addresses the issue of processed and packaged lobster meat. And for restaurants that buy that meat, right now they have to obtain a license from Fish and Game. And this bill says, and I do want to thank Paul Sanderson for working with us on the language. I know the department had some concerns with the original version of the bill and the way the bill was worded. We've simplified it, and it basically says, if you're a restaurant, you buy processed packaged meat from a licensed wholesaler or processor. So we're already purchasing it from someone that the department has some ability to regulate, to make sure that the fisheries are protected, then you don't have to get a license. And I want to thank Paul for working with us on that. It's a simple bill. I'm happy to answer any questions, but it passed unanimously in the Senate, and we're hoping for a quick passage in the House too. Thanks.
Any questions, Mr. Bailey? Seeing none in the room, seeing none online. Thank you, Mr. Bailey. Mr. Sanderson, you're going to speak to see if there's any comments relative to this for the department. Mr. Sanderson, are you there?
Thank you, Mr. Chairman. I have returned. And I really have nothing to add to what Senator Ricciardi and Mr. Bellew had indicated. The reason the department had concerns is because the entire set of regulations of lobster are not just in New Hampshire, but we also are part of an interstate compact called the Atlantic State Marine Fisheries Commission, which administers this type of regulations up and down the eastern seaboard. And so our concerns were about being as consistent as possible with our obligations to ASMFC. We believe with this very simple language that we will be able to make adjustments to our lobster rules, not only to protect these particular vendors, but also to make sure that we have protected marine fisheries and the lobstermen who are engaged in this from any particular negative impacts. And so I would like to thank Mr. Bellew and the Senate for their hard work on this, making the adjustments that they did, and we will proceed and make this work.
Thank you. Any questions for Mr. Sanderson? There being none, thank you. Is there anybody else in attendance that wishes to speak? If so, if you raise your hand, we'll recognize you. Seeing none, I will close the hearing on Senate Bill 51. We'll move immediately into a work session. We have plenty of time available this morning before we go to lunch and take a break. I'd like to discuss the bills we heard this morning and see if there's any consensus we can come around to whether we affect them or not today. And then we can also discuss, we have 3 bills we retained. I'd like to form a subcommittees for them and move them ready for agenda. Representative Spillane.
Thank you, Mr. Chair. I just have a question as the technologist here to clarify that we're seeing Representative Wolf online, but he was going to be out today as a substitute in the room. So we need to clarify which one of them is.
He will not be able to vote on any bills. He can listen only once, but he can't vote on any bills because he was excused by the speaker and replaced by Mr. Palmer.
Thank you.
All right. Why don't we take the easy one up? Senate Bill 51 we just heard. I'm obviously a little biased because my name's on this bill. But is there any of the hand raising? Sure. Representative Gottenville, go ahead.
I'm still struggling to hear LOB talk as opposed to people calling in. I can hear people calling in loud and clear. The folks that are at the table there, I can barely, you're barely audible, Chairman, as well as Representative Harvey and some of the others. I don't know if it's microphone position or what have you, but the sound here, and I think I see another rep who looks like they're struggling to get close to their computer too, to hear. I see Representative Ellis there. Thank you for shaking your head. But I think I'm really struggling here to hear.
Sure, give me 1 second.
Thank you.
That's the sound requirements.
Mr. Chair, can we take a fire break?
What's that?
Fire break?
Yeah, you can take a 3-minute break if you want to run to the restroom.
You need someone to speak to.
Yeah, I'll have you. This will kind of feel fine. If you could start counting 1, 2, 3, 4, 5.
1, 2, 3, 4, 5.
Did I get any better for you guys?
No. Roger says
The other
no.
way.
And I don't have a soft speaking voice, so some of the other representatives speak less loudly than I.
So is this, Mr. Chair, is this our,
That's your microphone.
Microphone?
Pull it closer, plenty of
so if we, all right, would you like Representative Laflamme to count now?
Sure.
1, 2, 3, 4, 5.
That's better.
And how about Representative Harvey can pick it up from there because she doesn't speak as loudly as I do.
Oh, yes, I do. 5,
I
4, 3, 2, 1.
Loud and clear.
We're good.
Thank you, much better.
Thank you, Roger.
Yes, yes, Mr. Chair, this is Representative Egan. That's much better. Thank you.
So Representative Egan, if you want to participate in the votes, because it sounds like we might go to a vote on 51, I'll need you to come on the Zoom link if you can find it. You can grab it off the house. page.
Correct. Are you going to set a time for that? Because then I'll make sure that I have connectivity, even if I have to
I'm
find another.
thinking we're going to do it right now.
in my
We're
current
just starting
apartment.
that discussion and then we're going to jump into a vote if everyone agrees.
Oh, okay. I will
I'll give you a
stay
couple
online
minutes.
via phone I'll stay online on phone while I get myself to a better area for video, and then I'll sign off and sign back on.
So going back to Senate Bill 51 after our slight break in, actually, be a minute, we're just waiting on it. Okay. What's it? Yeah, so now we just have a discussion amongst us on the work sessions. If we have no agreement on 51, we can take that and talk about some not.
Yeah, Mike did too.
They still need a license.
Those two.
Are you dangling cookies? Is that what
No.
you're doing?
We don't give away mulatto.
No.
All right, we're back.
More than he does.
No.
Mr. Chair.
Looks like-
I don't
Yes.
know.
Love stepped out.
I definitely.
I'm sorry.
Representative Love stepped out as well.
Oh, I'm sorry.
I just need a free lunch. Yeah, practice.
What's it?
There's a main number. Maybe they can try confirming that.
Oh, yeah, we'll give him a minute to wait for Representative Love as well. We're still waiting for Representative Love, guys. We got a couple more minutes and we're seeing if Representative Egan will join us now. So Representative Love stepped back in the room. We're just waiting on Representative Egan to see if he joins. We'll give him 2 minutes. And then we'll open. There's Representative Egan. We see you, sir. Can you hear us? You'll need to unmute.
Can you hear me and see me?
We can. Thank you very much. All right.
The wonderful.
So we're talking about Senate Bill 51, which is our least controversial bill of the morning. And we'll just open it up for discussion and see where the members kind of sit. Is there any concerns of this bill? Well, we should not pass it at this point. Seeing nothing in the room. Oh, Representative Howard, go ahead.
I just want to kind of clarify my reading of this. It says, under 211, 7:38, lots to meat. No person shall sell lots to meat which has not been processed or sealed within containers, do not require refrigeration. So I'm assuming that this license required for that process, is there also a license for selling live lobster?
That's the same thing.
So again, under current law, if you sell any lobster, you have to have a permit. So if you buy prepackaged from Cisco, you have to go get a license. And if it's just prepackaged meat for lobster rolls, you have to go get a license. If you sell live lobster, you also have to get a license. Under this current bill, because we're only talking about processed and packaged lobster meat, it would only apply to people who buy that lobster meat from Cisco. You still have live lobsters, you still have to get a license.
So restaurants that have live lobster still have to have an additional license.
Correct.
on top of Whoever they purchase those lobsters from.
Correct. And my understanding in the conversation is that this had to do with establishing a chain all over town of lobster that's there. So you don't have somebody buying lobster from the lobster off the boat and bypassing the entire regulatory process.
But doesn't that create a more expensive competition when you're looking at big processing companies and local lobstermen? Because you're forcing the restaurant to buy a license to buy from him. Yeah, not from a major packaging.
Nope, again, even if it's only if you're buying non-processed lobster, live lobster, either from a large supplier or from a lobsterman directly off the boat, you would have to have a license either way. It doesn't change. It does change. I will tell you the price of this license is $50. That's what we're
I
talking
know,
about.
it's just more government.
Well, we're trying to get the government out of the way.
Government fees,
Yeah, but the license already exists. We're trying to get it out of the way for some businesses under some.
Some portion of that.
Any further conversation? You think we're ready to go to?
Oh, yeah, I'm fine.
All right, so we're gonna briefly step out of executive session, work session and move into executive session for Senate Bill 51.
Slow down, please. Just 1 second.
Our clerk's gotta catch up.
Almost. All right, I'm in exec.
It's always one in every crowd, right?
Ready.
All right, so we're ready. I would entertain, we're moving to executive session on Senate Bill 51, and I would entertain a motion at this point.
That we ought to pass Senate Bill 51.
It's been moved on to pass on Senate Bill 151 by Representative Spillane. Second the motion. And seconded by Representative Close. Any further discussion on Senate Bill 51? Hearing none, the clerk will call the roll on a motion of ought to pass.
Right, Representative Khan,
Yes.
Representative Close,
Yes.
Representative Spillane,
Yes.
Representative Howard,
Yes.
Representative Craig,
Yes.
Representative Love,
Yes.
Representative McConkey,
Yes.
Representative Kittredge,
Yes.
Representative Dostie,
Yes.
Representative Smith. Representative Smith is absent, sorry. Representative Harvey,
Yes.
Representative Ham,
Yes.
Representative Dontonville,
Yes.
Representative King,
Yes.
the clerk votes yes. Representative Egan,
Yes.
Representative Shirtliff,
Yes.
Representative Ellis,
Yes.
and Mr. Chair.
Yes.
The vote is 18-0.
On a vote to 18-0 without objection, we'll place it on consent. Done. We will move back into our work session and discuss Senate Bill 129. Representative Shirtliff, go ahead.
Thank you, Mr. Chairman. Mr. Chairman, after all the testimony, I'm still concerned about the word acceptable. And in the letter from Attorney Sanderson, he mentioned the proposed new language is designed to move state law closer to the standards used by the federal agencies. And they relied on the Endangered Species Act of 1973, as well as the implementation of new regulations that were part of the combined federal regulations passed last year by Congress. And this is where the word acceptability came into play. And what one Congress can giveth, another Congress can taketh away, much like the New Hampshire House. I think, and we heard from the conservation groups and others that this is a very good bill, a much needed bill, but that word of acceptability does cause a lot of concern. And personally, I'd like to see the bill amended to remove that one word, and then I would have no problem supporting the passage of the legislation.
I think the words appreciably.
Appreciatively. Yeah, that's it. Easy for you to say.
I'm sorry, Representative Howard was next.
Thank you, Mr. Chairman. You know, I'm going to support this bill because it does tend to give some constitutional landowner right back to the people, but it comes at a cost, and that's the thing I have a problem with. You know, every time we turn around passing legislation that increases the cost of housing, this is no different. Like I said, I'm going to support it.
Thank you. Representative Klein.
Thank you, Mr. Chair. I had the same concern with appreciably at first, but after listening to the testimony and listening to the explanation from Paul Sanderson from Fish and Game, I believe that where you have appreciably used in line 7, but then the order for Fish and Game to define appreciably jeopardize in line 11, all we're doing is saying Fish and Game, now you can define what appreciably jeopardize means. It's no different than what we do, as you mentioned before, with giving them the ability to manage herds. They can now use their rulemaking to make a firm decision of what appreciably jeopardize means. They can then promulgate that decision to all other departments that they work with in the state so that everybody's on the same page. And they will have the ability to define that in rules so that if in the future the federal Endangered Wildlife Act changes, they can still redefine in rules a lot faster than we can deal with in the legislature what the definition of appreciably jeopardized means. It also gives them the ability to quickly adjust their definition if it turns out that we have impact to an endangered species that we didn't know about before. So I think that this is the best way to approach it, giving the flexibility to Fish and Game to define what that word means when it's used in conjunction with jeopardize. I would keep it.
I actually I disagree. I have a problem with that word appreciably. I think I support the concept of the bill in that it's pushing New Hampshire Fish and Game to make rules and regulations, but in a timely fashion. But considering that permits, the backlog is being worked through at least a reasonable pace, according to your information, then I think we need to take our time with this and make sure that we get it right. And I think appreciable is one of those words that's just too wishy-washy. So I could support the bill without that word if it could be amended, because I do like the concept of asking Fish and Game to make the rules and regulations. The only other issue I have with the bill, but without the word appreciable, I would support it. But I do have some issue with the idea of, yes, there were divisions of Fish and Game that would be reimbursed for unavoidable harm, but those reimbursements are voluntary. So it's up to the kindness of the heart of a developer as to whether they are going to supply the money for that harm. So that bothers me a little bit, but it's more the word appreciable. So I would like to see it amended without that word. We are the Fish and Game Committee, not Realtors and Developer Committee, and so harm to Fish and Game is harm to Fish and Game.
Thank you, Mr. Chair. I certainly understand the concern of people who think that appreciably is a little subjective. However, most of the language is subjective. What is jeopardize? What is harm? What is minimize? What is critical? So everything about this requires good faith. And I have confidence in our department that they will exercise this in good faith as it's intended to minimize any potential harm to any critical or threatened species. And I support it as written.
Representative Egan.
Thank you, Mr. Chair. I do concur with Representative Harvey and Representative Shurtleff in my concern about appreciably, but moreover, I have a concern that the demand that this will put on Fish and Game, an already overwhelmed organization that is underfunded by our state, and if these donations for financial support for services bothers me on Fish and Game that they have, and it's another reason why I actually appreciate being part of this committee. Is Fish and Game does so much for the state, yet we minimize. Sorry about that. So the internet is better on the road than in the house. The concern I have is that we're putting all of these demands on this agency, and now they're going to be working on behalf of realtors and contractors. And while I am a proponent of a solid and growing economy, we have to be smart about the way that we're going to push this agency to do things that they're not funded for. So that's my big concern with this bill, is that we're going to, while this backlog, I think, is some part by underfunded agency. And so I would like to look at some other ways that donation is maybe more of a, suggested contribution or some type of, if there's a bill that the contractor has to receive from Fish and Game to come out and do some of this work. I know that that happens sometimes with hunting. The folks will Fish and Game will come out and take care of animals for folks, and the farmer has to pay that fee. So that's my concern here, is somewhat with the language that gives it a vagary, and somewhat with the financial concern that I'll put upon the agency. Thank you.
Thank you, Representative Egan. I'm going to go to people who haven't spoken first, and then we'll come back to the second word. I do want to make one comment to that question, though. Either way, Fish and Game is doing this. Is that by the court order, they're obligated to review every AOT permit that goes to DES because of the court order, the court case that went through. So whether we pass this bill or don't pass this bill, they still have the obligation. So those 81 permits they had backlogged in March, they're still going to grow. I just happened to take a quick peek at our revenues because it's driven by the rep tax, our real estate transfer tax, and we're up 32%. So development is happening, and those permits in Fish and Game are going to continue. And the question is whether we give them the authority to manage and how we make them manage, whether we give them a funding source. So it's kind of what this bill is doing. But just understand that while we can talk about the fact that we're not the housing and development program, we also have to recognize the fact that they are in fact have to do this already by the court order. So we have to manage how we best manage that process because they have to do it. Representative Wolf.
Thank you, Mr. Chairman. Mr. Chairman, I am convinced after hearing all the testimony from the expert, especially Mr. Sanderson, that nothing will change from the locality, like our planning board, the conservation commission, and the regional planning commission, that they will have their say or their recommendation to the DES or other state agencies. I'm also convinced that nothing will change in my district where we preserve our piping plovers and other species in our seacoast, especially our pristine 16 to 20 mile seacoast in our state. So I will vote for this bill, and I also vote for this bill at the full house.
Thank you. Anybody else for Representative Love?
Thank you, Mr. Chair. I want to concur with Representative Howard. You know, everything has a price. You know, the word appreciable. To me, it's just stopping frivolous litigation. It gives Fish and Game a leg to stand on. It's their judgment. We could be looking at a 10-acre development that has 1,000 acres around it, and somebody could say, well, it's affecting deer tanks, okay? And then it'd have to be litigated. The project to be delayed with a cost the developers. But, and I do have concern too. Representative Egan mentioned about the funding for this, and he's going to take Fish and Game manpower, and I don't have a clue as to how much manpower. But without us passing this, wouldn't that I know in the state constitution we can't do an unfunded mandate. We'd be mandating Fish and Game to do this, and therefore it should be funded. So I'd like to see some language in there for it, but otherwise.
So on the unfunded mandate, that only relative to towns and cities. We can't pass down out of towns and cities. We can think as a state agency, do whatever we want. But relative to towns and cities, 28A is relative to passing down costs by passing the statute, not within state agencies. So we could move to agencies. Representative McConkey, you had your hand up. Go ahead, sir.
Thank you, Mr. Chairman. Pleasure to be with you folks, and I'll speak as a practitioner. There was a lot of talk on backlog and what that's causing to business and so forth. But the problem really started with a rule change in Department of Environmental Services that caused all of these applications to go to Fish and Game when it was only select that were causing or would cause harm to. So the problem really started with DES, and we heard some testimony that some folks thought that the impact, the fallout would not be what it was, but it turned out to be that. This appears, from what I'm hearing from the commissioner, will correct that, will allow them to move forward. I stand in support of the bill as read without amendment.
Thank you, Representative McConkey. Representative McKinney.
I had trouble with the appreciation. A word that isn't very exact in the context of what we're looking at.
Thank you, Mr. Chairman. While we're thinking about loading work on somebody, what about our court system? Secondly, this thing called paralysis by analysis. At some point, human judgment has to come in. I think we are making a lot of good steps in this direction of putting that decision in the hands of the people most informed to make that decision. I will vote for this bill.
Anybody else who hasn't spoken yet? Representative Spillane, go ahead.
Thank you, Mr. Chair. I just wanted to follow up because some conversation came up around the term voluntary that was used by Mr. Sanderson, and I was wondering if the chair would allow Mr. Sanderson to come back on for a clarification question, because I believe that one of the parties here in the room, whether it be me or one of the others, is misunderstanding the word you mentioned, voluntary. I don't believe that that was voluntary from a landowner or a builder. It was voluntary from the permitting agency, as in they could pass along part of the permitting prices and fees that they put on the building site. And so DES could voluntarily pass that along to Fish and Game or whatever agency was working on it. I'd like to get clarification on that. I also would like to emphasize that I don't think this is increasing the workload on Fish and Game. They have to do it now. From what I heard from Paul Sanderson, it would actually decrease their workload because they have to do every permit now. And this would allow them to now go back to where they don't have to handle every single permit that has a potential impact.
So unless there's objection in the committee, I will allow Mr. Sanders to come back and talk to the question of that voluntary payment to get clarification around what that means. Mr. Sanderson, are you there?
Yes, I am. Thank you, Mr. Chairman. If I could, to correct any sort of misunderstanding from my comments, let me make a couple of points. Once again, Fish and Game, as we go through this process, we make recommendations to other permitting agencies. We have no authority to impose any sort of exaction upon any particular applicant or permittee. However, as it moves over to the permitting agency through its particular program may have the ability to impose such a fee or such an exaction in accordance with rules or other procedures that they may adopt. Okay, so it is also possible for a particular applicant to make a voluntary contribution to Fish and Game. That is the voluntary nature of what an applicant may do. So let me please just make the distinction between these. Fish and Game cannot require an exaction. A permitting agency, through the adoption of rules and other procedures, could require an exaction. Any applicant is free to make a voluntary payment based upon their own determination. If I can get those three principles across, I will have done my job.
Thank you. I think that made it as clear as mud.
Still use the word voluntary.
So, Paul, I'm going to rephrase because I'm a simple guy. I like simple words. So what it sounds like to me, what you said was because you're not the permitting agency and DES is the permitting agencies of an AOT, authorization of terrain, that for the change of terrain, the DES could establish rules that would create some fee structure that would require fees for mitigation of habitat. However, you can't require that. However, that doesn't stop any contractor or developer from putting funds in because they're having a mitigation issue. Is that correct?
All of those are correct statements, Mr. Chair.
Thank you. Right. Any other questions for Paul while he's on? Go ahead.
Thank you, Mr. Chairman. Thank you, Mr. Sanderson. I'm just trying to keep track of how this works. So at the current time, after the Supreme Court case, all application for permits have to go through Fish and Game. What happens to those? How can I say this? So under this bill, the executive director would use his rulemaking authority or whatever to decide if a project appreciably causes problems to the wildlife habitat. And I guess his recommendation would then be Fish and Game's recommendation that would go to the permitting agency. Do I have that right so far?
Yes, you do.
Okay.
Now, I just want to make one small correction. When you say that all particular applicants for all particular permits now have to come to Fish and Game, that's only true for the alteration of terrain permits, and that's only because of the rule that several representatives have referred to that was adopted by Department of Environmental Services in response to the Supreme Court case that affected that program. Again, we deal with many different departments. We deal with other types of permits. And so it is the requirement for all right now is limited to the alteration of terrain program. Now, moving on to your next point, which is when we do receive a review and undertake a review, that results in recommendations that we make back to the permitting agency. They are recommendations because we are not the regulatory authority. We're not the permitting agency. the regulatory agency, the permitting agency takes that information in, and in general will incorporate that into the permits that they do in fact issue to applicants.
Follow-up?
Follow-up, yeah, Representative Plant?
In your esteemed opinion, how would this bill reduce or prevent the existing backlog?
I don't know how esteemed the opinion is, but in any event, what is actually happening in the discussion between our agencies is what has been reported to you, that we are going back to the system where the information that is being sent over to us is based upon information from the Natural Heritage Database. Instead of having every single alteration of terrain permit come to our agency for review, it would be those that do have positive information coming from the NHB database, the so-called NHB hits that you heard from several people who gave you testimony this morning. That will temporarily cause the reduction in the amount of reviews that we conduct and will reduce the amount of time in backlog. However, as we also reported to you, and as you've heard, the general economic condition that is out there is increasing the number of projects that are being proposed, increasing the number of permits that are likely to be filed, and that will increase, again, the number of permits and other questions that will come to us for review. That's why we're trying to send the information to you that suggests the current efforts that we're taking to manage are that current efforts, temporary, not the long-term permanent solution.
Okay, thank you.
Thank you, Mr. Chair. So I just want to pick up and make sure that I heard Representative Laflamme's statement correctly. So in his rulemaking authority, the executive director would have sole authority to decide which permits go forward to the permitting or agency. And that his decision is then considered New Hampshire Fish and Game's decision. Did Representative Laflamme say that correctly? Or did
Thank you, Representative, for your question. Not quite accurate.
Okay.
And again, remember, we work with many different agencies on many different programs. And so therefore, for example, working with the Department of Transportation, we enter into a memorandum of agreement or a memorandum of understanding with the assistance of the Attorney General's office to control the relationship between our two departments, okay, on issues of that type. And so therefore, it's not solely within the rulemaking authority of the Executive Director of the Fish and Game Department. That would also be true for Department of Natural and Cultural Resources. What we are talking about here is working cooperatively with the Department of Environmental Services and the Alteration of Terrain Program. That's why we conducted our request for comment in advance of rulemaking jointly, so that as we try to adjust these two aspects of program, the AOT program and our response to the AOT program, the two departments are working together such that both sets of rules will go to GELCAR on a consistent schedule, and that we will work cooperatively to try to manage our problem and try to manage our effort to more quickly respond to these requests for information.
You know, I think the more I listen to testimony, I'm still confused. I'm just confused on a higher level.
So let me see if I can clear one thing up for Paul, maybe. Having served on GELCAR now for my third term, you don't understand what the rulemaking, it's not like the commission just writes a rule and says, okay, this is the new rule, go do it. That has an entire process behind it that has public hearings and public input. And then when they're all done doing their public hearings and public input, and they come out with an adjusted rule, that rule then goes in front of GELCAR, Joint Legislative Committee on Administrative Rules, who then reviews the rule again and makes recommendations and considerations for adjustments to that.
No, that part I get.
So understand, well, I'm not sure everybody does. I know as a freshman, I had no idea what they put me on. I'm pretty sure speaker, I think it was, which speaker it was back, Jasper, was penalizing me for something and put me on GELCAR. But I just want to make sure freshmen understand what that rule process looks like. It's not just one person sitting in a room, creating a new rule and making it follow the state. So there is a significant amount of public input, public comment process, as well as the length of time, because the period of time is statutory requirements for how long rules have to be open for public comment and all that. Kind of thing. So there's a pretty significant process for that. So I guess this is where I go back to, again, the only word we seem to be really focusing on is the word appreciably here.
Well, I moved past that.
Yeah, well,
But
for me,
so my question is, I just want to know who at New Hampshire Fish and Game, when there's been one of these requests for a permit, one of these backlogged requests, who at Fish and Game reviews it and decides that it is harmful or not harmful and should move forward to whatever the next steps are. Who at Fish and Game makes that determination?
so Paul, I don't know if you've heard that question you want to answer. So the question comes down to is there a biologist or who's looking at these AOT permits requests that are coming through right now in your agency, and how's that determination made regarding the appreciably jeopardized standard?
Thank you. Yes, I did hear the question. The answer to that is this referral comes over to our wildlife division. It is then specifically delegated to the non-game program. The supervisor of the non-game program works with one full-time wildlife biologist and one half-time dedicated to this particular program. And those three individuals work together to take a look at the specifics of the individual case and make a determination of the level of review that is required to provide recommendations in that individual case. So it is the wildlife division and non-game program with those three specific employees who make the determination and communicate back to the permitting agency or the other state agency.
So the executive director has nothing to do with it.
Well, we all work for the executive director. Me too.
Any further questions from Representative?
Just wanted to make a further potential clarification on this. Where the executive director comes in is in kicking off the rulemaking process to define the definition of appreciably jeopardized the continued existence of such species in the rulemaking, which essentially is setting the bar that Fish and Game will measure against. The biologists make the determination of whether that bar has been reached or broached, or whether they're well within bounds of that. Correct, Paul?
Yes. All of our authority within Fish and Game flows through the executive director. I am the person who actually drafts these in cooperation with our other staff, but I don't actually attempt to promulgate a rule without the permission of the executive director. The exact criteria that may be contained in there is reviewed by the executive director before we file formal rulemaking and go through the process in GELCAR that Representative Lang described to you. So again, all of our authorities flow through the executive director.
Anything else, Mr. Sanderson? Thank you, Paul. So we're back
Thank
to
you.
the general discussion on the bill as it stands. Again, my position is that, this is to a certain extent a bill of trust. Whether we trust the wildlife group, the three employees we just spoke about, as they review this, and I'm sure they're going to have input into what this word appreciably jeopardized means, and that phrase in the development of rules, and whether we trust that they'll manage this process and do this process, or whether we think the legislative authority put that in. I'm not a fan of absolutes personally. When you take out that word appreciable, it becomes an absolute statement, which I think means we have an absolute lawsuit going forward. And the appreciable gives the wiggle room that will allow Fish and Game to properly manage this AOT process that they've been thrust into by rule from the ES and the court order. So that's my take on it. I'm going to support the bill as it's written. I think that I trust Fish and Game and the wildlife group to properly define it. The only thing I don't like about this bill is a chicken and egg problem we have, but we can't create the rule until we pass the law, can't create the law until we pass the rule. What do we do, right? And so I'm going to err on the side of trust and trust Fish and Game and say that I having been involved in GELCAR, like I said, for the last 3 terms, I trust their process. They take significant input from public. They adjust their rules based on public input. And I think that they can better define what appreciably jeopardized means than we can in our. So with that, we're out of So that being said, what I think we're gonna do is I'm gonna take, we're gonna go into recess for 20 minutes. We'll come back at 11:30. And we'll allow for some brief caucuses. So I'm gonna ask, I'm gonna stop the meeting and we'll ask the Republicans to stay in the room. So Democrats step out and take a wild break for 10 minutes, and then we'll step out of the room, give you the room for 10 minutes. And allow you to just have a conversation. We'll come back at 11:30 to decide what we want to do, whether you want time to go get an amendment or not. And then we can decide on that exactly. Sound reasonable to everybody? Yes. Great. So we'll be in recess for 20 minutes. We'll be back at 11:30, and we will have a caucus, Republican caucus right now for the next 10 minutes.
Chairman Lang.
Yes.
I'm sorry to interrupt. I just wanted to let you know that the meeting will technically continue. You can mute the video and the audio. And I'll do a share screen that says how long the committee will be in recess.
Great, thank you.
Thank you.
Representative, if the Republican representatives want to give my phone a call at 603-566-9802, I should be able to get 2 or 3 is on my phone. I can throw you on speaker so we can hear in the room.
Let me know when you want me to view it. Tell me.
Can you,
Could I ask for that number again, Mr. Chairman, slowly?
603-566-9802.
980 what, sir?
2.
Thank you.
Hey, Larry.
Hi, Steve. We're having, we're having a little caucus.
I sent an email saying I'd follow Catherine's lead, but I didn't think an amendment was necessary.
Hey, other people are on.
Oh, we have no secrets.
I can't hear hardly anybody in the LOB.
Thank you, Roger, for speaking up. I couldn't hear either. And yeah, it was bad.
Thank you, Donna, for leaning in because I knew you were doing what I was trying to do.
In the stream.
Jeez. I didn't hear Love at all, and I could barely hear Howard.
Yeah,
It was tough.
yeah, it was. I could hear.
And when
you.
Tim backs away from the mic, I can barely hear him.
Mhm.
How about you, Mark? Can you hear everything clear? Yeah? Wow.
Well, after they adjusted the microphones of the sound, it was okay.
Yeah.
And then it dropped back down.
Some of it did, yeah.
Okay, Honda. I sent a text to Catherine. I don't know if she got it.
So did I.
Yeah, I
And
sent
Larry
an email.
and Tim. How about you, Tim?
Welcome back.
What about me?
Can you hear stuff from the LOB pretty clear?
I can. You're actually, I have to turn my audio down when you talk because you're loud and everybody else is low and I have to turn my audio up. So I agree with you that it's a little low in the room, but you're probably having more of an issue with it than me.
Yeah, he's the deaf man shouting.
Yeah.
More issue than I is the correct English, I think there.
Thank you. I failed to correct you on that inaccuracy.
Speaker. I did. I unmuted and turned on the camera.
All right, guys, give just a couple of minutes for everybody to take their seat. Someone's got a mic on. So just a couple of minutes, get everybody in their seat.
How's it split?
All right, looks like we have everybody back. We will move, we'll stay in work session for just 1 minute. I believe we're probably at a point where we're just gonna take a vote on a motion on this bill, unless anybody has anything appreciable to offer. No, it's like appreciable. All right.
Could you define that word appreciable that you just used?
Sure, substantive. All right, so we will move into executive session. I recognize Representative Spillane for purposes of a motion.
I'd like to move OTP on SB 129.
It's been moved by Representative Spillane, ought to pass by on Senate Bill 129. Representative McKittrick. I second that. It's been seconded by Representative McKittrick. there any further discussion on Senate Bill 129? There being none, we'll go to a roll call vote.
Moment. Representative Khan,
Yes.
Representative Close,
Yes.
Representative Spillane,
Yes.
Representative Howard,
Yes.
Representative Craig,
Yes.
Representative Love,
Yes.
Representative Mark McConkey,
Yes.
Representative Kittredge,
Yes.
Representative Dostie,
Yes.
Representative Smith is absent. Representative Harvey,
No.
Representative Laflamme,
No.
Representative Dontonville,
No.
Representative King,
Nope.
the clerk votes no. Representative Egan,
No.
Representative Shirtliff,
No.
Representative Ellis, No. And Representative Oxal is absent. The vote.
Representative Lango,
Mr. Chair,
Yes.
thank you. The vote is 10-8.
On a vote to 10-8 on a motion of ought to pass, the bill passes. Minority report?
Sure.
Who's going to be responsible for it? So Representative Hardy will write the minority report, Representative Spillane will write the majority report. Any of the other discussion? Great, we'll move out of executive session.
So we used to have blue sheets or something that minority reports were
So,
written.
so regarding the minority and majority reports, if you just type it up and send it to Representative Reed as the clerk, she'll get yours and Representative Splane's together, forward over me for final approval. And then I'll send it off to the, clerk.
You want that by?
Next, end of the week, great time. No great rush, I don't think it'll be in the House calendar until we're ready for session, so it's going on the regular calendar. Great. Talking about this afternoon. So we have two provisions, and I meant to pull up Senate Bill 46 because I couldn't remember the second provision we had. So at 1 o'clock over in RRD, they have Senate Bill 146. Senate Bill 146 is an omnibus bill coming out of the Senate. That bill has one provision that belongs to environment and ag, two provisions that belong to fish and game, and two provisions that belong actually to RRD. And so what we're going to do is myself, Representative Spillane, Representative Reed are going to go over into the RRD room. The committee chair there is going to turn the meeting over to me when we talk about those two issues, those two items, number 3 and number 5. In the committee, I'll manage the committee meeting while that goes on. We're gonna hopefully change this into a Zoom, so you'll zoom into the meeting as a participant in the meeting and be able to ask questions when we get there. So when we're done with that hearing on those two provisions, we will come back to this room and reopen our meeting and the work session. We'll take a vote on those two provisions, the straw poll vote. It's non-binding to anybody, but it's basically our recommendation, R&D on those two provisions. Do we think you should keep it and pass it? Do you think you should pull it out of the bill because it needs, pull it out of the bill because it needs more work? And then R&D will make their vote. On the end, ours is just a recommendation, has no binding effect on them at all. Just gives them a recommendation of the Fish and Game Committee on what we think of those two provisions. If we think it needs more work, they may choose to just strike it and have somebody resubmit a bill next year. We like the idea, but we just think that the bill's not ready for prime time for that section. They'll put an amendment in and strike it, or they'll leave it in the bill. Is basically, from my understanding, that's going to.
Maybe I missed it because I was writing a note to myself. If I don't write things down, I forget. So just you and Representative Spillane.
3 of us can go in, so it's going to be myself, the technologist, and the clerk.
Okay.
We'll go in and listen. The rest of you will be on Zoom. You'll be able, when we get to the point of asking questions of witnesses, I'll recognize the room and anybody in the room. And Representative Abul will kind of help sort who's up next to speak
So
in the room.
we will all have the opportunity. to
You'll
speak.
all be able to ask any questions on any of those, on the two provisions. We'll take them one at a time.
The order, though, that was explained to me is that we're gonna take questions from people in that RRD room first on the bills, then we're gonna ask questions, get questions from this room, and then go to the public.
Yeah.
If they have any. So it'd be in that order.
Or the R and D reps will be
Yes.
next.
But we're gonna, are we doing that on each section?
We're doing 2 sections, we're doing
Yeah,
on each section.
but we're
So
gonna have the
presenting
questions
section
and everything
one,
on each
and the
section?
witnesses for section 1, ask that question, then we'll have witnesses for the second section. And we'll have witnesses for there, be able to ask questions.
Okay.
And then we're all done with those 2 sections, we'll come back to this room, go into work session, take a straw poll
Hands up.
and a non-binding vote.
But after our sections are done, not,
After our 2
not gonna
sections.
wait till the whole thing's done.
No, just our 2
Excellent,
sections.
thank you.
Representative Egan, go ahead.
So just clarify, we'll be on this same Zoom link for those discussions this afternoon?
Nope, you'll have to disconnect from this Zoom. Well, if you're remote, you can just disconnect from this Zoom link and go over to the House page and grab the Zoom link over there. And just use
For-
it from there.
For our.
Recreation, resources and development.
Okay, and then that,
So if you're remote, you should join remotely.
and that
You can
time
do-
again was 1 PM?
Yep, 1 PM. So if you're remote, you should go over to the R&D page, grab the Zoom link off of there. If you're in the room, you'll be able to use the existing room here and use the microphone here.
So,
Thank you all.
but if they get that Zoom link, they're only,
We can promote it.
okay,
Right, they can raise their hand and we'll promote it if they have questions.
and
Uh,
how do we get the Zoom? link?
We'll disconnect that one and start a new session and for the R&D.
So I have no idea what to do now.
We'll take care of it before we leave, before 1 o'clock. I'll make sure we're on the R&D.
that's true. Let me know.
Representative Shertliff, go ahead, sir.
Thank you, Mr. Chairman. Mr. Chairman, I've got to leave for another meeting this afternoon, so I won't be back at 1 o'clock. But before I go, I do want to thank you for the wonderful job you did in conducting these hearings and thank the whole committee for their outstanding performance as well. So thank you all.
Thank you, Representative Shertliff. I appreciate the compliment. I'll tell you, I learned it all from you as speaker.
That's a bit of Bonnie, but I like it. Thank you.
All right, guys. So we'll stay in recess for lunch. We'll come back here around, I'll be here for 12:55 to get that set up. And then at 1 o'clock, we'll be in the 3 of us will be in the R&D room. We'll go from there. Thank you, guys.
So we should ask Jen what she's gonna do with this.
So I think she's gonna have to stop.
Representative Lang,
Yes. Jen, do you want
just
sit down and talk to
just
me?
to clarify, I was wondering, so our meeting will need to continue for streaming purposes. So we can let the public who tries to tune in kind of know when you guys are coming back. Do you have an approximate time when Fish and Game will reconvene?
I don't. I think we'll probably be back. I don't anticipate more than an hour, but I don't know how many witnesses they have. I haven't seen the sheet for R&D to see how many people are testifying on sections 3 and 5.
Okay, so do you think it's okay if I post 2 o'clock right now, or do you want to?
Sure. You can just say
Okay.
roughly.
Okay, and then I'll pop down and come work with you guys on the equipment.
Great, thanks.
Okay, thanks.
So I can,
Yeah, you guys can go. I'll catch up with you over.
can I close
Okay,
this
so,
now?
Marty House, please, that's open.
I thought somebody said.
I just looked, their Facebook page said they opened it.
Okay. so
I have
yeah,
not
they're-
called.
I don't know if it's updated, but it used to be Tandy's or,
I'll call them real quick.
I can always go to Farley.
Marley House, the other place.
She's changing it. Changing it from 11:30 to 2 o'clock.
I just gotta figure out how we're gonna minimize this and do a second.
No, I'm all
Right, I know.
We'll look at that. We'll figure that out.
That's what I was wondering too.
Put this back on charge.
And it might take you my laptop, everything, or.
Yeah, we're gonna help me.
Oh, let's make that big.
Oh, wait. So far we have Conkey, Ellis, Roger. I seem to be the best lit. As far as lighting, as far as
I was
lighting.
gonna
is
say,
concerned.
did you have a drink at lunch?
As far as lighting is concerned, I'll have you know that plant-based
Yes, well, that's wine.
beer, wine,
Beer,
vodka.
That is all plant-based.
It is all plant-based. And there's a cat finally.
But he,
Roger has a
vouched
cat.
he did not. He was here in the room. He's
Roger's
just-
cat is gonna give her a hard time.
He's just expounding about something.
I wonder if I was a vegan, if I'd have to buy special beer. I wonder if I was a vegan, if I had to buy special beer.
No, for a long time, Guinness Stout was not vegan. Because they had fish bladders.
Ew.
Ah, okay.
They no longer use fish bladders.
Yep.
Were you drinking them?
They use it to clarify the beer. It actually pulls the yeast down out of the beer.
Oh my God, that sounds disgusting.
It's really delicious though.
I want to know who job it was to. Hey Patty, we've been needing some more fish bladders.
All right, so I'm gonna convene our work session. It's 2:01. So you guys heard the testimony on Senate Bill 146. Our goal for today at the end of this work session is to take a non-binding vote that we could give to, and recommendations that we could give to the R&D committee, let's exec this bill permanently and deal with it. I'll give my 2 cents worth, and I think you probably heard my testimonies. The first one on section 3, that we have to change that one word from emergency order to executive order, because you can't do an emergency order unless you have a state of emergency, and yet I think the idea was to allow the governor to act quickly on something using the executive order powers and then later follow up with statute if we need to, but because of the timing of that process. But,
Sorry.
nope.
That process is already in place for Department of Health and Human Services. I forget the RSA that they operate on.
So 141C does have some sections in there relative to human diseases, but it wouldn't stop the importation.
It's 53 semicolon 35 or something. It's under the DHS.
Yeah.
That they can, under say, they can create an executive order.
Right.
And, for an emergency.
Right, they create a declaration of public health emergency, not a governor's state of emergency, but the language in the bill particularly talks about the governor.
Yeah.
And an emergency, and an executive, it says emergency order, but I think it should say executive order. And it just allows the governor to write an executive order saying you can't bring in XYZ fish because of this known pandemic, right? And that would stop the importation of that animal into the state. So on section 3, that was the only change I had that I would like to see.
Really seems to me this ought to be an agriculture issue instead of fishing.
I made that comment when I was in there.
Yeah, I think it's what Thomas, it's one of those weird, it's animals, right? And so you have wildlife and then you've got domesticated animals, and how do you manage the two?
I really want to know who's selling monkeys and rats and bats for food.
Exactly, because it does say specifically for consumption.
For consumption.
I can see, like I mentioned escargot,
Mhm.
I can see somebody selling that live. It's the best way to get it is fresh. Or, freshwater crawfish that we do have in New Hampshire, might be caught and sold for eating. I don't see that covered, but he said there's leeway in there to cover it, so.
And did it specify food for human consumption?
It says for human consumption.
Okay.
Yeah.
Representative Plan first.
I don't think, I believe that the sale of wild animals is prohibited in New Hampshire. You can't go out and catch rainbow trout and sell them. You can't go and sell your deer.
No, you can't sell your deer. there's a difference between an animal you've tagged, like a deer or a bear, or if you're a restaurant, I believe you can go out and catch fresh rainbow trout and serve them in your restaurant. So,
Really?
so,
Okay.
but you cannot go out and shoot a deer and then serve that deer in your restaurant and sell it.
Because you have to have a
You
tag.
can give it away.
You have to have a tag for the deer meat.
So it's different if it's tagged.
Gotcha.
If it's a controlled tagged animal, moose, deer, bear, turkey.
So I'm done catch and release.
So, I forget now, Representative Love's comment about, well, you know, who's eating rats and monkeys right now. It's my understanding that this is also maybe a preventative bill for something that might come down the road in the future.
I definitely think this is a future looking bill.
Right.
It's not
I mean,
about what's happening right now.
Right,
It's
yeah, I
that
wouldn't
4%
be a-
know that eats bats at Ozzy Osbourne. I think that's what we got.
The idea of eating a rat right now sounds pretty, expensive to me, but, you know, who knows what people in 20 to 30 years, who would have thought people would eat pangolins? I mean,
What?
pangolins, where the pandemic came. Yeah. Pangolins, they're disgusting.
It's like an Asian
They're also
armadillo.
endangered. Anybody else on section 3 have any
I
changes
think
they
a few.
think we should recommend or not recommend? And are we okay with the bill as it goes? Let's take a straw poll. All those in favor of the bill with the one recommendation of changing it from emergency to executive, just signify by raising your hand. Is there anybody opposed? I don't see anybody opposed. So the recommendation on section 3 to the R&D committee, Ellen, this is where you need to type, is to recommend passage with one language change, and that is the replacement of the word emergency with the word executive. Yeah, we'll get to that.
Chairman?
Yes.
We're just voting on part 3, right?
Part was just part 3. We'll meet separately and we'll make recommendations on each part. So having taken a straw poll and everybody being the affirmative on 18-0, I'm not sure how many we actually have, but something to 0 vote with a quorum present. We're going to recommend section 3 go forward with the one language change. Moving on to section 5, this is the one that deals with derelict cleanup fund, derelict fishing equipment and gear cleanup fund, and the creation and the fees associated with that. Again, my only comment is I want to get rid of the language that says fishing for energy, which I just seems like a foolish line that's in there, and it's open for all kinds of misinterpretation. I think the name of the fund should be nothing more than
Derelict.
yeah,
Cleanup
it should be derelict fishing gear and coastal cleanup fund, and that's it. And there's nice and clean. Yes.
So if we did that, I mean, he explained that he put that word in there because there was one specific fund that has that name, and possibly this money could go into that fund. So if we took that name out and just left it broader, derelict fishing funds, could it still go into that one that is named?
So because we're not changed down below, it talks about what the fund can be used for. And this is where I would go to the fishing. There is a fishing for energy program.
Right.
I think it's always a bad idea to have a state program after a federal program. So you never know idea which one you're really talking about for the programs. So it's an OSHA, not OSHA, the NAO, whatever. It's a
National
Oceanography
Oceanography Institute.
Yep, program that deals with, they'll put out dumpsters, basically allow fishermen to put stuff in. It's a federal funded program at this point that's named Fishing for Energy. So I'd rather not have a state fund named the same, but in the bill itself, it says that the monies for this fund shall be used, establish and support new and existing programs to retrieve and dispose of derelict fishing gear, to conduct periodic coastal cleanup programs for the removal of derelict fishing gear, marine trash, and to support recycling efforts for fishing gear and other marine trash. So I think under that last section, the recycling program, which is what this is, it covers what they want without having to put the name in the fund, which is, I think, just confusing.
Well, and also you said it says existing programs, and so this is a program that is already existing. So it could be by keeping the name broad, then possibly there may be other things that
Right, again,
be
so
appropriate
to
as
the
well. So-
Khan's comment, right, so again, I know that Seabrook and Hampton Beach have beach cleanup programs, right? So they could in theory apply for a grant from Fish and Game now to help offset some of the costs of the town
Beach
incur for the beaches cleanup, beach cleanups and stuff that goes on. Same with the Great Bay, right? So anything that's washing ashore and areas in Great Bay that have beach, that have derelict stuff washing up and cleaning and rehabilitating beaches again.
Yeah, sometimes when you get specific, then people are like, well, this wasn't in the bill or this was in the bill. Yeah. Okay.
So that's all. I just think that having the two names is confusing. I think we strike it, makes the bill more clean. Very fine. This is about explorers for cleaning beaches up and they're collecting derelict gear. When you add the word energy, you start getting people going a little crazy sometimes about energy. So I think it's just a cleaner language for the bill.
I just want, thank you, Mr. Chairman. I just wanted to let all the members know that our town DPW cleans up the beach. Every time we have the big storm, a lot of those equipments and everything comes to our beach. And our DPW cleans up. Also, in order, just for everyone's knowledge that the Yankee Fishermen Club, the land they use, the Seawood taxpayer donates their land, lease their land for $1. So we're doing our part to funding this, just that the Seawood taxpayer is doing it.
Yeah, resources bill is currently in the state. Representative Howard?
Thank you, Mr. Chairman. Just to clarify something, Representative Concept. How much of this abandoned fishing tackle is due to storm, as it related to storm issue?
It's lot. It's depending, it's lot.
So this isn't because guys are out there just tossing stuff overboard. It's a lot of it.
Like cost going.
Accidental, right.
Yeah, it's true. Is there anything else in section 5 other than my recommendation of striking that one language and renaming the fund and striking everywhere in the bill that says the name of that fund? That fishing for energy. Representative Swain?
Yeah, I still have a problem with the timing issue, just because I think for existing fishermen saying, okay, we'll give you credit because you helped with the cleanup last year, it's great. But if you're a new fisherman, you come into the program, you buy your license, there's nothing here that says you can get the discount, you didn't participate. So the first time fisherman that's joining it, I think is gonna end up paying for it, even if they want to participate. So I would love to see them add in this section that's repeated everywhere, where it says, any person who satisfactorily demonstrates to the executive director that he or she is participating in a coastal cleanup program shall not be required to pay the surcharge. I'd like to see it say, or shall be offered a credit on the subsequent year's fishing license for their participation. Just so that it says, you'll get a credit next year for what you did this year.
I understand the timing issue is tricky, although Mr. Sanderson was very adamant that would be ironed out through the rules and so forth, which we gave him a lot of leeway this morning on. But I think what you're saying is it happens automatically. So you pay for your license this year. You don't get the credit because you're a first-time fisherman. Then you participate in the program, so you get that credit then the second year on your license because you participated in the program in between the two licenses.
You're right. Maybe what I was thinking would have been rebated back to you.
What difference
after
does
you
it make whether you
participate, so
get
that you get it back this year while you're on the license, but then I suppose it would be an ongoing rebate.
Exactly.
Forget it.
Anyhow, the cost of these licenses are a limited commercial license is $400, a regular commercial license $600. I'm pretty sure they're not going to screw about $2
$10.
that they're going to go into it. So.
Just a thought on that word. What if you have it, so a first time license purchaser?
That would allow them to not pay it the first year and then continue going forward on good faith. And if they don't participate the first year, they're paying it the second year. That would probably clear up the timing issue.
It's the same.
Yeah, yeah,
But it's the same difference. You're either getting your discount the first year, or you're getting it the second year.
No, but he's saying any first time, you don't pay it the first year. But going forward, if you didn't participate that first year, you don't get the discount the second year. So you know, how we just talked about the fact that you might pay for it the first year, but if you did the cleanup, then your next year you get it free. Well, this would say, now you've got the 2 years free, because you don't pay it the first year. If you participate, you get the second year free as well. And you just need to
Representative
participate.
Kittredge?
Thank you, Mr. Chairman. Yeah, I agree with you about cleaning up the title of the bill because the blurb doesn't include the part that you'd like to excise. I think that would be consistent. Secondly, I was just curious, considering the point that was just discussed, the director has discretion, you know, as to when it's going to be applied.
Yeah.
You know, I think we can trust the guy to use some common sense. I hope so. But that's, you know, and finally, what is this about scallop fish, scallop divers?
So there's an amendment that was put in that we have very few scallop and urchin fishermen, and it just exempts them from the fee because.
I think that's shrimp too.
Yeah, from the scallop.
Shrimp, scallops, and urchins.
So I'm not sure, but it was a deal that was worked out between Fish and Game, the commercial fishermen, and the senator. And
Yes.
everybody seems to be in agreement that.
Because I'm pretty sure, you know, a free diving scallop fisherman doesn't have much in the way of gear that he doesn't wear and bring home.
Right.
Representative Flan?
No, I was just gonna say that commercial scallop fishing, you're dragging the bottom, you're not actually out there trying to pick them up.
Thank you, Mr. Chairman. I just want to make sure that when we say lobster license, we should always mention that commercial lobster license. Otherwise, it's not going to go anywhere. People will be confused, all the general public, and they will say that our lobster, the license is going up. And legislator went up on lobster license. We should say commercial lobster license. And also, just one second, also, when a commercial fisherman, new fisherman applies for a license, he or she willing to pay $400 and knowing that they're going to make money and they're not making for pleasure. They are commercial fishermen. If they have to pay $10 more or $15 more, it's normal. That's all I have to say.
Representative Khan's comment brought up a good point, but add on to this now. We get the commercial lobster license, and we just doubled the lobster bill. Would this have to be paid as a surcharge to everyone who buys the commercial lobster license, including the guy selling the live lobsters in the grocery store? Who's not going out there to clean up, because he's not actually doing any active lobster fishing. He's just buying the license.
It must be a different license.
Is it a different lobster license?
It's not for lobster harvesting, it's for lobster.
Sales?
Sales
Okay.
or what is it called?
All right, so Ray, is
The
there
word that I'm
anybody on
trying to
that,
think of.
on remote that has a question? or comment
Processing.
They'd like to add?
Processing.
I just wanted to add to Representative Spillane's question there. Yeah, I can tell you that the supermarket has a lobster license, but we can't go lobstering.
Right.
So, no, it's different license.
It'll be fun, though.
All right, so right now, the recommendation would be to just accept the bill as it's written with the name change of the fund to strike that fishing for energy out of everywhere in the bill. So it's just the derelict, the derelict fishing gear and coastal cleanup fund. Does that sound good? Anybody want to add to that?
No, I'm voting.
Okay, it's already there. All those in favor of that, signify by raising your hand. All those opposed? Great. Last thing we have to quickly discuss, and I found my little cheat sheet, is we have 3 bills we retained. I'm going to form 3 subcommittees. To hear those 3 retained bills, we have to have the report out of the subcommittees by no later than say September 1st, so that we have about a month, 2 months, I can schedule a full committee hearing on, once we get the subcommittee report. And then we'll have to act on it to have a report to the House by, I think it's November 1st. We have to have the reporting, and then we'll vote on the actual bills at that point that have been retained. And that'll be a recommendation going for the first meeting in January for next year. So we have House Bill 118, which is relevant to the Fish and Game Commission. And the first named person is gonna be the chair, Representative Khan, Representative Spillane, Representative Howard, Representative Reed, and Representative Oxon. On relative to trout, House Bill 241 is gonna be Representative Khan, Representative Spillane, Representative Reed. And on House Bill 490, permitting the use of live action game craft, to be Representative Khan, Representative Howard, and Representative Oxley. So those will be the members of the committees. The chairman of the subcommittees will work with the members on the committee to schedule that, and I'll work with him to make sure he understands that process. We'll have the subcommittees set up for some time over the summer, or anytime we can start on it to get it out of the way. We just can't vote on any bill until September. We're holding bills just in case we want to tag something onto it. If we exec it, then we're stopped, we're done. We don't have votes taken. And so if something comes up between now and then, we need a bill to append something to. We want to keep these bills in play until October. And then we can vote on it in October, get the committee report to the House for November 1st, and it'll be in the calendar for January.
Just one question, because where everybody is here, the question is, when will be there will be a time for this committee member to have our first meeting, and then we'll go on. But it's important to have that time.
I would look after our next House session. The next House session, I think, is going to be sometime in early June, maybe the end of May. I'm not sure. I haven't heard exactly, but I would look at, either late, just starting around July 1, anytime after that. Just every year meetings. I'll work with him. And again, talk to your committee members. You can meet whenever you want.
Yeah, that's
Want to meet
why I
tomorrow,
asked.
but can't meet tomorrow. You need notice. But you want to meet next week, we can make that happen. But you can talk to your committee members, start a little email chain, and find out what works for them. And then if you want to meet in June, that's fine too. So, and you get paid mileage for here. So, anything else to come before the committee? Not seeing anything, we will adjourn.
See you.